Well, I'm seeking your lordship's leave. Yesterday, I mentioned the matter in the morning. Yes. I'm seeking, I want to move it at 2 o'clock.
No, tomorrow.
My lord, we want to file a cross
He's
appeal.
appearing for the other respondent.
I am appearing for the other respondents. We want to file one cross appeal, my lord. And Mr. Bhattacharya, Mr. Vikas Ranjan Bhattacharya is appearing in this matter, my lord. My lord, can it be posted on Tuesday?
No.
Because there is no.
I want.
My lord, urgency has to be satisfied, my lord. So far, the urgency in this matter is concerned. My lord, according to me, there is no such urgency. My lord, the only question is, my lord, because your lordship is allowing one appeal to be posted tomorrow.
No,
So,
he has mentioned it yesterday.
my lord, the only thing is that there is an injunction on the suspension order as well as the other orders passed by the proposed president of this governing body. Now, today morning, when the principal of the college went to the college as per the order, she has been prevented by the police to enter into the particular college. My lord, this particular matter has a checkered history. When the matter was taken up by the Honorable Justice Vishwajit Basu.
Mr. Chatterjee, let it appear before us. You take the point, we shall hear you.
So, in that case, my lord, my cross appeal be taken up.
No. In that case, we are satisfied with what you are saying. We will pass appropriate order. Yes.
It will appear tomorrow.
No. It will appear tomorrow. Your state and board and everybody.
The lordship, we have some reservation. If it is posted tomorrow, because we have to file the cross appeal, I will make my submission tomorrow in that case. If your lordship is
tomorrow,
because my lord, there is no such urgency. Can it be?
It cannot.
It is not the matter of satisfying someone's ego. It's the matter of doing justice. It's not so urgent, my lord. The principal of the college. My lord, we have prepared, my lord. We will be filing by due course.
File it by today. File it by today. It shall appear along with the appeal.
Can it be posted on Monday instead of?
No. We are objecting.
We have. This is not a matter of satisfying someone's ego.
It has to be understood that the principal should not venture inside the college and create a chaos.
That's the only thing.
She should not enter the purpose. We will come back on Monday.
Principal will not go. Someone who is not connected with the education will go and.
Appearing for some non-teaching staff,
and I do not have any conflict.
He's appearing for whom?
I am not having any conflict with the principal. Someone who doesn't have any educational qualification but trying to sit over the educational institution and grab it.
Every platform cannot be converted into a political one.
But where is the political one?
You can't convert.
Someone who is not connected with the education, can it be said to be political? No. And everybody is a political animal. You are, I am.
You are for the principal.
No,
here I am for the
in the secondary
petition. I am appealing for the.
Kindly visualize. There was a writ petition carried to your lordship's court where Mr. Chatterjee had the occasion to intervene in the proceedings. I am appearing for the governing body.
The writ petitioner, who is the writ petitioner?
Principal. In suspended. The principal moved your lordship's court. The first writ petition was assailing a show cause. Allegedly by a governing body which is, according to the principal, yet to be constituted. That was the case. In that proceeding, Mr. Chatterjee wanted to intervene, which was not allowed formally. He wanted to intervene on behalf of the so-called
Forget, the show cause was challenged.
Yes. Thereafter, during the pendency of the writ petition, since there was no order, the governing body in its prudence thought to place the lady under suspension and to initiate appropriate proceedings. That proceedings is yet to be initiated. We have asked them to lay their hands. Now, both the second writ petition was carried to your lordship's court, assailing the suspension part. Now, both these writ petitions were heard, not on affidavit.
What order?
It was heard by Honorable Justice.
Sir, the
Advocate General wanted the release of the matter. Matter was released from the Honorable.
What was the order passed?
The order that has been passed is, staying the operation of the suspension and the show cause. And all consequential orders by the governing body of the college, which according to the Honorable Judge is yet to be constituted in terms of the 2017 Act, Section
It
5.
is a question of joining the college now. She is being prevented.
No, I do not know about prevention. We have no instructions on that. That is a new story, my lord, which is coming up.
That is,
Which is a new story.
All right, let it appear tomorrow.
Very
My lord.
Yes.
may I have your lordship's kind leave, my lord, to mention a matter. My lord, an order was passed on 11th of July, my lord, this year. Your lordship sees this is, my lord, regarding certain questions in an exam known as, my lord, the TATE examination, which is the qualifying exam for, my lord, the School Service Commission. Now, my lord, the question paper was challenged, credible material was brought, a committee was appointed. That committee didn't submit a report on, my lord, certain questions, which is why this order was passed, appointing, my lord, the Vice Chancellor's nominee of Presidency of Jadavpur University and of the state government to carry out an exercise and submit a report within 3 weeks. That's at page 3. My lord, 11th July order, 3 weeks. My lord, nothing submitted. So, my lord, we have prepared an application. My lord, if they don't submit, the only option is to send it outside the state. If they submit, it can be taken on record and I'll pursue, my lord, my remedy before the
Mentioning
writ
upon
court.
notice.
No, I have prepared an application. Kindly give me leave. I'll affirm it. Kindly let it appear on Monday. My lord, I'm not going to disturb your lordships. If they have come with, my lord,
It is automatic. You file an application, survey copy, it shall appear. It will appear on Tuesday. Tuesday.
but it's a disposed of
Oh, it
appeal.
is disposed of.
Yes, but I want a modification of this order because there was a 3 week time period not done. So therefore, my lord, further orders. But I have a feeling and I'm
There
told,
was no rider as to what will happen after if it is
no,
not.
no.
There's no default clause.
No, there's no default clause. Naturally, my lord, if the report comes, report will be sent to the learned single judge and the writ petition will be decided finally.
Then it
But, my
becomes
lord,
a
today,
contempt.
if I go before the learned single judge and I ask for, my lord, any other committee to be appointed, that's, my lord, that will amount to a modification of the division bench order. So I can't do that.
No, you can go in contempt before the division bench.
Not contempt against, my lord.
That is a better option. Otherwise, you have to
No,
face
it will
the
only, my
initial
lord, I
burden.
am told, my lord, that the report has been done. State government is sitting pretty with the report. If your lordships entertain the application, they'll come and file the report. Your lordship can dispose of the
You are
application.
appearing.
No, no, my lord, my lord, I'm just praying for leave. Please permit the application to appear on Monday. My lord, I'm just affirming it so that it appears on Monday. There's some urgency.
On
Further,
Monday, it will appear. On Tuesday, you file it. Give notice 48 hours. Yes.
my lord, Wednesday in that case, my lord, if your lordship.
Wednesday, give notice.
Sir, may I permit to mention for inclusion in the list?
Hmm.
May I permit for the inclusion in the list?
Huh?
For the inclusion in the list, may I permit to mention?
Application?
Matt,
What is it, a hearing matter or a application?
no, application.
Huh? Final hearing.
No.
Was it hard earlier?
Earlier, it's hard.
So, in connection with the MAT, did you file any application?
No, that is, I don't know, my lord.
Please ascertain and mention.
No, my lord, appellant lost his job due to the cancel of SLS 2016. Thereafter, he successfully employed in upper primary selection process. Appellant prayed for joining in the list. Joining
Your application file was hard or not?
it is hard on single bench.
You have filed any application in connection with this MAT?
This is not can. Yes, can 1 of 2025, my lord.
Was that can hard?
This I'm not aware of, my lord.
Then what you are mentioning, sir? Is it a new application? When did you file the can? Do you know?
No, my lord. I'm not aware of.
So you ascertain, no? Have you served notice?
No, my lord.
Then serve a notice. Come and tell us on Monday. Yes.
May I have your lordship's kind leave to mention? I'm mentioning upon notice.
Yes. Tell us.
Yes, Your Lordship, this appeal is a Surfacey appeal. I had mentioned last week as well, Your Lordships had sought clarification as to why it's appearing before Your Lordships. Now, Your Lordship, this was against an impugned order which was passed by His Lordship Justice Bashak, and therefore, when it was listed before Justice Bashak and Justice Rashidi, it was released from the list. And it was appearing before Your Lordships, and Your Lordship's last order.
No, whose order was that? Initial order was of Justice Boshak.
Yes, and
Against that you preferred appeal.
yes, Your Lordship.
Against Justice Boshak's order.
Yes, Your Lordship.
It is pertaining to which determination? Writ petition was under which group?
Surfacey, Your Lordship. Group 9.
Now you have to go before the regular bench.
Your Lordship, they had released the matter. It was reassigned before Your Lordships. Your Lordships had heard it.
It has been assigned to us.
Yes. Your Lordships had heard the matter.
If you দেখো,
However, when this matter appeared on the 3rd of September, my senior was on his legs, Your Lordship. So we had sought a passover, but Your Lordship, now this has gone out of the list, Your Lordship. So, Your Lordship, there's urgency because the bank has taken physical possession, Your Lordship, and I am for the bona fide auction purchaser. We are fearing that they may alienate the property, Your Lordship.
assigned কি আমাদের কাছে? এটা কি assigned আমাদের কাছে? বুঝতে পারছি না। Better
Your Lordship, my senior was on legs and the junior had.
after vacation.
Yes, Your Lordship, but Your Lordship, there's urgency in the matter, Your Lordship.
How can we prepone the date when we have said it will be out of after vacation?
Your Lordship will kindly consider the urgency.
It will appear on the reopening, on the list. এটা লিস্টে দিয়ে দিন।
I'm grateful to Your Lordship.
May I have your lordship's leave to mention? There was a resolution of the bar on that day. The learned advocates of the respondents had not appeared. Your lordships had given us leave to mention if it was not reached. My lord, this is that matter, my lord, a hearing matter where we have not filed a stay application. There's no scope for it.
Who's your other side?
My lord, Mr. Rahul Kormukar is for the private respondent. Mr. Tanvir Mondol is for the state. My lord, I have informed both of them. My lord, this is upon notice. But we'd only pray for
We understand.
listing paper book directions.
You bring them, you.
But I have informed them, my lord. It's in fact, my lord, my junior, my lord, he has also affirmed an affidavit of service of their notice of mentioning. But if it comes up under to be mentioned, my lord, tomorrow, my lord, I'll inform them once again, my lord. I'll serve a notice on them during the course of the day.
We
my lord.
mentioned Tuesday.
Grateful, my lord.
I am for the appellant, madam. I am for the appearing for the respondent number 4.
I
State
am appearing
proceeding.
on behalf of the state led by Mr. Pinakidor.
Pursuant to your lordship's last direction, my lord, I filed the supplementary affidavit. madam.
Copy page supplementary.
Yes, tell us what is the matter.
I was appointed as a para teacher. Subsequently, my lord, my service was extended up to 60 years. Thereafter, my lords, I participated in the 2013 Panchayat elections. After taking the permission from the managing committee, my lords.
During your tenure.
Yes, my lord. After taking the permission from the managing committee, my lords, I elected as a pradhan. And my lords, when I serving as a pradhan, my lords, the salary credited to my account, and I return back by making a demand draft to the DPO. Thereafter, my lord, the DPO, after hearing my lords, passed a resign order and terminated my service in 2015.
What was the ground of termination?
That, my lord, they said that they have a rules that they, without any resignation, the para teacher is not participated to the panchayat elections. Thereafter, this order was challenged in the earlier writ petition that was taken by His Lordship, My Lord Justice Arijit Banerjee. And My Lord Justice Arijit Banerjee, setting aside the order passed by the district project officer, remanded back to the secretary of the assistant secretary, my lord, to fresh consideration as per the GO of 2014. And after, my lord, at the time of hearing, the 6th April 2018, another GO was issued by the government of West.
What happened? Next, when it was remanded back,
They are rejected, my lords, on the
they have rejected. Then you challenge that order before the single bench.
bench. And single bench, my lord, after hearing the submission, my lord, this
Now
is
you are yet to complete 60 years, or you have completed 60 years by this time?
no, my lords. I am not completed 60 years. I am not completed 60 years. My
What is your age? You have still how much period of service left?
lord. 52 years. Only
9 years is left, my lord.
Then what is this, what you are wanting from us now? What application you have made?
For reinstatement of the service as para teacher, my lord.
So that is a final relief you are seeking.
Ma'am.
At interim, what you are wanting? Have you all the pleadings are there on
Yes, ma'am.
record?
By way of supplementary affidavit, I filed the affidavit of reply and the affidavit in opposition, my lord.
So it has to be finally heard. Have you given copies to all?
Yes, ma'am.
All the pleadings are on record. Very good. Then we will hear out the appeal.
yes. There is no scope of an interim. Lord.
Yes. Will you file a paper book enclosing all the documents? Huh?
Yes, ma'am.
সুবিধা ভালো।
সেটাই ভালো, একটা paper
এটা
book
সুবিধা।
করলে তাহলে সুবিধা হবে।
Where is the order which you impugned in the writ petition?
The page
6th
73.
April 2018.
Yes, ma'am. Page 73. September 2018.
September.
Yes, ma'am.
Where is that order? 6 September order?
Page 73, my lord.
73.
Ma'am.
Where is the 3rd December 2015 order?
3rd December 2015. Page 60, 60.
66.
60.
Ashok. The present appeal has
Mukherjee. Sohili Mukherjee. I am for the appellate, my lord. I am led by Mr. Dr. Sopon Kumar Dutt. Your lordship's passed an order on 3rd September 2025. There was a direction upon the writ petition of respondent number 1 to file opposition, and thereafter your lordships also directed the appellant to file a reply by 17th.
not
But
filed.
my lord, I could not.
Opposition we have prepared.
By
We will file the
Monday.
clock.
By Monday, we will file, my lord.
It is
Kindly
a
allow.
pension matter when I oppose the prayer for section 5 application. I have your lordship.
His affidavit is on section 5.
Section 5.
So you have filed,
We
not
have
filed.
complied your lordship's order.
By Monday, I will.
But prior to vacation, it cannot be.
No, well, it is a pension matter where retirement took place and not receiving
Keep it
pension.
on reopening, Mr. Bud.
On
Ashok.
Tuesday, Wednesday, is it possible?
হবে না।
No, section 5 it is allowed, no problem. If the section 5 rejected, everything will be.
Come on. Mr. Badi Learned Advocate appearing for the writ petitioner.
But I challenged the order dated 12th of August 2025. The crux of the case is the participation as a legal year in the managing committee.
Yes, what is it?
The participation as a legal year in the managing committee of the deceased founder member. The
Yes.
order dated 12/8 of 2025, Lord. The relevant paragraph 5 and 6, 7. The honorable
12.
trial judge will not dismiss the writ petition on merit by observing the paragraph 5, 6, 7, and 8 of the impugned judgment below. Page 8 onwards. May I read?
Yes.
Sir, while passing the order, Lord, the honorable trial judge did
Have
not
you served upon the managing committee?
No, no.
Eh?
I have served the state only.
The managing committee করতে Where is your service upon the managing committee?
And I have not served, Lord, I have served the state
How
responsibility.
to serve it?
Well, statute,
Yes, Lordship,
statute does not provide the founder member.
We will consider.
Lordship kindly sees that at first below 69 rules.
Are a
rules
complete
5B.
service, sir. Complete service. The
The appointment of teacher in charge. A teacher in charge was selected by the school authority. The advocate appearing for the school authority, Mr. Badi. Mr. Badi's junior is for the teacher in charge.
No, in this matter, I am not appearing his junior. I am independently appearing
Yeah.
as in favor of the
B.Ed
teacher. in
better
charge.
আরে কংগ্রেসদের সব বলে ছাড়ো না ওগুলো মনে করতে নাই
that as it may. But, a person has been appointed as a teacher in charge who is much junior in the seniority list. That will appear at page 39 of impugned order at page 120 of my stay petition.
Page, Mr. Bhattacharya.
120 of the stay petition and the memo of appeal, the order is also. In the meantime, approval has been granted to the teacher in charge.
Yeah.
I tell you,
Right here.
I could not run faster than the DI. On that 2nd of September, order was passed. 9th of September, we have given copy to the DI that we have preferred appeal. We have 8th of September, we filed the appeal. 9th of September, we served. He has received it, but still 10th of September, he has given approval to the post of teacher in charge. So what I am praying is this one.
কত 6 না 7
This is item number 6.
7 এর ফাইলটা দিয়েছে
সেভেনের ফাইল দিয়েছি কোন ফাইল দিয়েছি সেই জায়গায় স্যার
সেখানটাই Yes, what you are submitting then, Mr. Bhattacharya.
Order has been passed approving the appointment of the teacher in charge of the petitioner during pendency of the appeal. That will definitely will be abide by the result of the appeal. At this stage, yesterday Orshu had a view that there is no scope of entry. I agree to that. But all papers will be making a compilation of all papers in the stay petition, affidavit filed by the parties, and a supplementary affidavit that taken place subsequent to filing of the writ petition.
You are for the DI?
No, I am for the Mr. Bosu only.
Approve করে দিয়েছো? You have approved the appointment of Mr. Badi?
prior to filing of the application.
No, appeal was filed on 9th.
But your lordships kindly go through the your lordships kindly go through the order of the single judge.
Initial defense was taken in the stay petition that I was implicated in a criminal case. 351 charge was there. Because I did not allow someone to enter my house, I push them out of my house. A criminal case was there. My Lord Justice Shogota Bhattacharya stayed the further proceeding of this particular appointment of the teacher in charge. No teacher in charge proceeding was stayed by the Justice Shogota Bhattacharya. Returnable matter came before my Lord the Honorable Justice Chatterjee, my Lord Parthasarathi Chatterjee, where they have manufactured some document showing that the students are alleging against me.
No, then in the writ petition, affidavits were exchanged?
Yes, affidavits were exchanged.
Ashok, the present appeal has been preferred challenging an order
home factor.
Read petitioner is the daughter of the deceased. First application was by the widow. So widow's application at the time of making such application, she was within the age.
No, she was upper age limit exceeded.
At the on the date of
On
filing
the date of filing application within the time, but at the age of 48.
he filed within 2 years of
Yes,
demise.
within 1 month.
So, but she was overaged.
She was overaged.
So her claim was ultimately dismissed when?
In the year 2016, that is the cracks of the matter.
It was
At page
mother's
59.
application was dismissed on 29th August 2016.
Obliged to your lordship. The moment it was rejected, immediately thereafter, applicant before your lordship made an application.
When was that application?
Within very specified date of 2016. Kindly come to page 60.
No, very good. Now, after rejection by DI, you filed an application independent in 2016 itself. And that was rejected by the authorities.
DI, ground is this, your application is time barred because you have not filed within 2 years from the date of death. Twice jeopardized. Why I say tell your lordship? If your lordship kindly,
how twice jeopardized? She have made that application initially.
Initially, mother made.
No, Mr. Bishar, sorry. Kindly come to page 60 once.
60, yes.
Mother's application was made on 29th of August 2016. Correct?
No,
Mother's
10th
decision.
2013.
Sorry,
Mother's
this he has
decision.
rejected. Now, while it was pending, the daughter made the application.
No.
No. Immediately thereafter, knowing to
No,
the.
No. Yes, while it was pending, daughter made the
It
application.
was.
Yes, madam.
It was pending. But decision has been coming one after another.
Mother's application was made on 10th June 2016. Is it right?
Mother's not, appellants. Mother's application 10/6/2013.
That is what we are saying.
Correct.
That is page 48.
Page 48.
Now, that was forwarded by the madrasa on 15 January 2014.
My lord.
And it was rejected by DI on 29th August 2016.
My lord.
Now, when did the Roshanara Bibi make the
My
application?
lord, kindly see at page 58.
16th of June 2016.
Yes, madam.
16, yes. My lord, kindly come to page 58.
That is before the prayer was
Decision
rejected.
pending. If you lordship kindly
No.
take, yes.
Made
page
application to the
58.
school authority on 16th of June 2016.
Hmm.
But it was reached to the DI only on 19th September 2016.
It was page 58.
It was
18,
reached to the DI on 9th September 2016. That is after the rejection of mother's prayer.
No, Mr. Bishwas, against one expired, one case can be considered.
My lord, subject to correction. Subject to correction. I have that answer to that extent. Even then, I am making my argument in that my own. My lord, kindly take two dates. Father expired of the appellant
On
17
17 January 2013.
Immediately thereafter, 6 June 2013, mother's application. Well, mother application
was kept pending.
Knowing
about
fully
6
well
months?
acceptance is there by the authorities for taking decision. On that date, admittedly, my lord, my mother was not eligible to.
No. When did you attend when did you become overage?
My lord, on the date of making application itself, mother.
So prior to 10 June 2013, you were age barred.
Yes, madam. Even at the time of death also, husband's death also, he was age barred.
Very good. Then what is your argument, Mr. Bishwas? What is your argument?
Now, admittedly, on the date of making application, mother was overaged, admitted. Made an application. Group 8 pass, a lady made an application. Her application has been pipelined. Acceptance. It should not have been accepted in the threshold, thereby eligibility criteria is not fulfilling. They could have decided the matter taking this plea in the year 2016, which has been done within a 6 months. Although there is no guideline or rules that it is to be decided within the period as stipulated, my Honorable Supreme Court says, in this type of compassionate appointment, decision is to be taken very
promptly.
Admitted fact. Justice Nagarata's judgment I have. If I put those judgment in between, I can make a bridge. That is why my.
Had the mother's application been delayed, had your mother been an otherwise eligible candidate?
Otherwise, they could not have accepted.
No, there is.
Now, if that application could have rejected
Could have been
or
rejected
accepted
within the time.
the 2 years time, then application of the appellant would have been made within the 2 years of the date. Subject to correction, madam.
That point you cannot take, because on the date when your mother made the mistake, on that date the daughter ought to have applied. Now, having allowed the authorities to take a final decision on your application for compassion, you now cannot take a point. All right, my appointment was overage, you dismiss, consider my daughter now.
Now, if your lordship kindly sees page 58.
কি করে শিফট করতে পারো তুমি যখন অ্যাপ্লাই করলে তুমি যখন তুমি জানতেই পারো বলেছে যে যেহেতু এখন এই অ্যাপ্লিকেশনটা ফাইল করেছে বিয়ন্ড 2 years.
Now I'm telling you. Now page 58 says, prior to taking decision by the DI in respect of the mother's application, the school authority forwarded that application of the Roshonara also.
So when did you apply?
And I applied during the pendency of the mother's application.
Very
Mother
good.
made application
You-
that I could not continue with the service.
But that was beyond 2 years.
Beyond 2 years. That
Huh.
is there. Now, if not subject to correction,
Yes.
if such application of the mother could have decided, I have said so.
We understand you that had your application been rejected before expiry of 2 years from the death of her husband, then you could have come
Made an
within the zone.
Because it's a benevolent.
Assuming you are right. Assuming you are right. Can you generate a right after a right was exercised by a person and was rejected?
Not subject to.
Can in respect of one post, 2 applications, then another application rejected, again another person will come. I am the son, now you consider my application.
Son has all the other legal heirs has given no objection to.
No, no. Hypothetically,
Hypothetical, yes.
suppose I apply knowing that I am ineligible and my application is pending. I do not take any step, though it was incumbent upon them to
And
consider.
I got your lordship's point. Whether twice it can be adjudicated on the self-same issue. Now, my answer would be, if they could not have school authority or madrasa authority itself could not have accepted on the ground of law, a lady of 8 pass may not. Although your lordship can say they are ignorant, cannot take the place of law. It was the school authority who made the mistake accepting my application, my mother's application. Another your lordship's desire was to place the Syed Khadim Hussein's judgment. In that case also, they have made an application within
That
that.
has been said to be not laying down the law by the division bench.
By
You
the-
know that. By the division bench.
Yes.
Sayyid Khadim was passed in the facts and circumstances of the case. It will not have the force of Article 141. Not a binding precedent.
Now, subsequent decision of the Honorable Supreme Court also held, and 2010 also Supreme Court says overage person's application has been accepted, although there is no statutory rule for giving exemption, because the authority since accepted, it should have been considered in the appropriate manner and giving this appointment to the.
Had there been the sole application, had he
Yes,
been the
I got
sole
your lordship.
application.
There are 2 applications. That is why your lordship stumbling.
No, we are not saying that, but the facts of this case is not in sync with the facts.
But apropos fact. But ratio I am telling whether benevolent legislation can be in a rigid manner. That
You
is
are a married daughter.
no unmarried daughter. Unmarried daughter. If you lordship and decision
Family pension you are getting.
mother getting, but that
Mother
cannot
is
be.
still alive.
Yes, that cannot be taken into consideration.
And what does your brother do?
Staying separately.
How many brothers? You have?
One daughter, one sister of deceased. Daughter and son, one another. But decision taking by taking upon another rules itself, that is not applicable to my case. That is also the DI
Mr.
did not.
Vishwas, second application is a bar. If I apply even mistakenly and withdraw my if there had been a withdrawal also, we could have understood. You allowed the application to be dismissed. Okay. The desperate attempt to equalize school ought to have considered
আমি সেটাই বললাম
in accepting. Where's the order of the DI, Mr.
Yes. 2 orders, page 59. And I stand corrected also. Pending decision of the mother's application.
You made the application.
Yes. 6/6/2016. আমি সেটাই বলতে চাইছিলাম। Page 59.
Page 59.
My lord, of the stay application for appropriate order. এই রুলটা বার করতে নোটিফিকেশন জানি তো ওটা তো পাঠিয়েছে পেজ 58. But prior to that, kindly take page 58. Prior to that, what was the communication of the school authority?
Page 58.
Yes.
It was forwarded on 18th July,
July.
2016.
That is prior to taking decision of mother's application by the DI, by the school management authority of the madrasa, relinquishing the claim of the mother of the petitioners in lieu of taking application of the appellant before your lordship.
18 July 2016 is the application of the
Daughter's application has been forwarded to the DI.
What is the date of daughter's application?
6/6/2016. Now, keep your lordship take the list of dates.
6/6.
Well, it was sent to the DI on 9th September only. Letter written in 18/7/2016.
Mr. Badi will come back to you. You already have a good case, so you take your seat. He is having a let us hear him. List of dates টা কোথায় দিয়েছো?
No, in the writ petition itself, it is there. Petitioners pay mother paid for. Thereafter 16/6, petitioner made an application.
Page.
Kindly take.
না আমাদের এখানে আছে।
Writ petition কি annex করেছিস রে?
Right.
I'm giving this. Yes. Writ petition is annexed.
6 petitioners mother paid.
Page 17.
And he made, she
Page
made
70.
16th of June. petitioner মা করেছিল 6/6/2016
in favor of the petitioner. Petitioner mother paid for appointment on in favor of the petitioner. মায়ের অ্যাপ্লিকেশনটা হচ্ছে 10th June 2000 application made by petitioner's mother.
পিটিশনার যে দরখাস্তটা করিল মেয়ের জন্য সেটা ইজ বিয়ন্ড 2 years.
Because of the
illness, but that also was 2 years after the date of
that is there. Now, kindly take page 59. 59. Impugned order in respect of the decision taking of my mother's application. In your lordship read, taking course of 6797 rules. Totally non-application of mine.
9
rules is not applicable to the case of madrasa. It is a case of school authorities.
In madrasa, that period is 2 years or more.
2 years, but there are certain provisos there. In respect of the minor's application, it is 4 years from the date of death. There are other rules also. A totally complete code of rules. So, if the authority takes decision not in consonance with the prevalent rule in respect of the particular case, But section में paragraph.
So you show us under the madrasa rules, it can be considered even beyond 2 years.
Some interpretations are otherwise. If your lordship takes.
No, interpretation, tell us.
Proviso clause are there. I am also not meeting that I have read. I must be candid to your lordship. But there are certain provisos. Kindly see text. And that rule is totally different from the impugned orders rules.
That you were not the lawyer then. You did not take it.
My lord, take my lord page 880.
Rule? What is the?
This is the rule governing the field of madrasa.
All right.
Rules.
2010.
Yes.
This rule is of 2010.
10. Governing the field at that point of.
Show us which rule.
Rules 32. And regarding compassionate appointment.
Achha. Rule 32.
Yes.
Where is the time?
Yes, limitation. Column number 4 and 5, next page 881. Kindly read limitation and applications. That provides a clause also there.
Place it.
Yes. Application. The
first line is against you.
I know this. I know this.
Please place it.
Yes. And may I read 4 and 5 also get.
What is sub rule? Yes, read. Only one.
Eligible candidate. Eligible member. Because of the fact my mother was not eligible on the date of making application. So they could not have made my mother in the pipeline itself.
I just told my lord this is going to be your argument.
My lord.
Only.
I have read time and again this is clauses.
Only one.
Only one eligible members of the family may be
appointed. So till appointment, eligible person
appointed under the provision of sub rule 2 of this rule. Appointment on for only one.
Applies within the time set.
What is not candidate applies is rejected. Can another person
We have also read.
One mistake was there on the part of
One
the
mistake.
daughter also, that age covers. If underage is the cracks, was not underage.
Not above 45.
See, two persons, there can be only one application for one post. Now, only one eligible person can be appointed to that one post.
That is.
There are number of cases where the mother widow applies within the time, saying that my daughter will make the application when she will attain the age of majority.
That is the Khadi motion following Iptika judgment of there.
But
Continue.
Mr. বিশ্বাস, how can we apply discretion in this?
I thought that since it is a benevolent legislation, of course, apart
Cannot
from
go
the
beyond the scheme.
beyond the scheme, but if the authority, not that one, if I read that line itself again, so far my interpretation, only one eligible member of the family may be appointed, but he does not say more than one application may be accepted or not.
It cannot be made because you have to annex no
Because
objection.
if eligible application was there, then they could have.
What is an eligible application? Age,
as well as the 48.
One is age. Second is whether no objection obtained.
Yes.
Third is whether the school has forwarded it.
Yes.
These are, and fourth is financial disability, 2 square meter.
That will come later if that I go
You,
through. Yes.
but how can we say, Mr. Vishas, that we cannot go beyond the rules provided in case of ineligibility of the spouse and underage, the application may be made?
Then 4 years is to be reckoned. Then 4 years.
Did your daughter attain majority on the date of application of mother?
That is also against me. I must be careful. At the age of death, if it could have been 17 years on the date of my father, then I go through for 4 years within that time.
Would get that extra 2 years.
Yes, that proviso is there.
You're 17.
In case if the spouse was ineligible also.
4 বছরের এটা।
এখানে provided that in case of
Proviso clause could have been in my case if I was junior at that point of time of death.
তাহলে কিন্তু চলে আসছে।
ট্রান্সফার ওনার্সটা শিফট করতে পারছি দ্য ডেট অফ অ্যাপ্লিকেশন তুমি কোথায় লিখে যাচ্ছি কথাটা বলো জানতে হলে বলে দেওয়া ভালো সত্যি কথাটা বলে দেওয়া ভালো
আচ্ছা Mr. Badi, why can you apply this proviso? Why cannot you apply this proviso? এই প্রভাইসোটা দাও।
Yes, so yeah.
এই proviso. Provided that in case of ineligibility of the spouse, underage of the dependent, the application may be made beyond 2 years but within 4 years from the date of death. Into spouse to ineligible
and underage. It's not either or.
সেটাও ঠিক বলেছে, দিয়ে দাও। এই sorry Mr.
Some decision may I place?
Sure. বসো তাহলে decision.
My argument was that within 6 months there was a guideline of the Supreme Court itself could have been decided. Then I could have made an application in that line. May I show the judgments?
But Mr. Vishas, here the story is totally different.
And the authorities did not take care of the appropriate rules which was applicable. That can be said.
No, that we understand.
Whether this.
No, if we apply this rule also, we will say that we have, instead of sending it to the DI, we are deciding.
That That is, I
One argument of yours can be that it has been decided under a wrong
Wrong.
rule. So you send it back.
my lord,
That was not an argument before the single judge. First. Second, whether did you take a ground to that effect in your writ petition?
I believe so. I believe.
Acha, what was the order passed by Honorable Justice Soumitra Pal?
Well, it is in respect of similarly circumstances matter, the delay attributable by the authorities concerned in taking a decision, petitioner cannot be faulted.
You did not take that ground also, Mr.
No.
Anyway, we shall consider your
I leave it.
which judgment you want to refer.
That is the judgment of Justice Nagaratna.
Yes.
But, taking recourse of that earlier rules, it is to be reckoned at that material point of time date, which rule was prevailed. Paragraph 14 says there was a specific direction for paragraph 14 or no, 14, 15, 16 at page 3. Ruled heavily for delaying the matters in respect of compassionate appointment.
পড়ানোটা খুব সহজ, এই যে মাইন্ডটা অ্যাপ্লাই করছো যে কিছু দেওয়া যায়, this is the merit of justice should not be তিনটে প্যারাগ্রাফ no wasted right, exception is article 16 এর exception আমাদের মুখস্থ dismiss it in 5 মাইন্ডটা অ্যাপ্লাই করছো। সেই রুলটা আমরা সেই plus over and above this it's Unmarried daughter gets the family pension till 25.
No, therefore,
It has been
what larger bench decided and Honorable Supreme Court upheld, unmarried daughter, there is no concept. Daughter.
no,
All.
I am saying the
20, up to age 25 or not? No,
family
that
pension.
relaxation also got.
That has been removed, no?
Your Lordship,
Till marriage.
Till her marriage.
Till her.
Your Lordship
Till-
judgment is also part of that judgment itself. Purnima. Special bench. And upheld by the Honorable Supreme Court.
No, that was not on the ground of 25 years.
No.
Your government circular initially was unmarried daughter
Unmarried, divorce, marriage, all these things are
will
there.
be up to 25 years family pension.
Initial.
Now 25 years has been omitted.
Yes.
25 years someone can have only in respect of
Daughter.
in respect of son 25
No, majority.
Yes. No, 25 years.
So,
It should have to 25 years. Huh? What
The order under P is one dated 26
want us to keep it on that date?
On that day, my lord, only the cause title is to be corrected, my lord. There is a defect in the cause title. Without your lordship's leave, I cannot correct it.
Which one?
My lord, the cause title, if your lordship takes page 20.
Passed any order? We passed any order? We
Lordship?
passed any order?
No. Previous bench directed
Which
me.
order your rectification you are wanting?
Not order. In the cause title.
Oh.
The cause title of the writ application and the appeal does not tally. So there is this effect because there was a direction that since the time has lapsed, that is why matter went to the department. I inquired with the department. Department said it would go to Lozima court. But since the timeline has lapsed, that is why it has come before your lordship. With your lordship's kind leave, my lord, I can correct the cause title.
Leave was granted, Mr.
Yes, that could not have been completed. Yeah, I know, my lord, that this could not have been completed. The file went down to the department.
Oh,
So that's why it
could not be done within
within the time. That's why it has come before your lordship, my lord. My lord, kindly take page 24 of the that is the cause title of the. না, অনেকগুলো চেঞ্জ আছে তিনটে হবে না হ্যাঁ আমি করে দিচ্ছি my lord it would be easier if
what was the
yes my lord kindly take page 24 of the application, that is the cause title of the writ petition, and 24 of the stay application. So onwards, 24 onwards, that is the cause title. And my lord, kindly take the memo of appeal. It will be convenient for your lordships to consider the cause title in the memo of appeal. So side by side, my lord, I can assist your lordship regarding the correction. 1 to 4, there is no problem. Problem arises at 5 in the memo of appeal. It has been added wrongly, my lord, due to inadvertence. It has wrongly been added.
No,
It has,
5 is DI.
5 was 4.
no, my
5
lord,
was 4.
page 25, my lord, kindly see. 4 is DI Medinipur.
Oh, twice you added.
Twice it got added.
One will be the other one will be Dokhin Dinajpur. Instead of
Yes, I'm coming, my lord. This 5 in the memo of appeal will be omitted.
Dokhin Dinajpur to আছে.
Yes.
5 মানে 4 নম্বর
Only 3 changes are required. Only 3 changes.
You have made DI Paschim Medinipur twice.
Yes, that is the first correction. That is the first.
Arekta?
Second, my lord, kindly come to the next page of the memo of appeal. This 6, 7, everything is perfect, my lord. This in the writ petition, page 26, DPSC Paschim Medinipur has been omitted. It is not there. DPSC Dokhin Dinajpur is there. Paschim Medinipur is omitted. এটাকে অ্যাড করতে হবে, হ্যাঁ, it is to be added.
এই লিভটা 1 সপ্তাহের জন্য দিয়েছিলাম we can give him the
Yes,
leave to correct here and
After correction, let him serve a copy. We have
Yes, I will serve a copy. I will
why it will go to Lojima, you are saying? Any registered notice given?
No, if since the timeline has lapsed, so they said that it would go to. I inquired with the Lozima, then said no, only your lordships can extend the time. So it has come before a lordship. If your lordship kindly grants me the leave by extending the time, I can do it herein now. 2 would be omitted, 1 would be added. That much, my lord. Due to inadvertence, it has happened, my lord. হ্যাঁ, কপি পেস্ট করতে গিয়ে ভুল করে, ঠিক আছে।
No, leave was granted to, it will now go down in the department, no?
No, your lordship allows me.
That was not given to you on the earlier occasion.
Earlier occasion, that's why it has come before your lordship. Kindly grants me the leave and let it be fixed on the next day whenever it suits to your lordship's convenience.
When did we fix that?
4th November.
As prayed for, leave is granted to the learned advocate on record of the appellant to make necessary correction in the
Lord, I appear for the petitioner.
Appellate.
Appeal.
Lord, I'm for the state.
Milord, the order to work.
Delay, Mr. Bose.
Delay. কতদিনের delay আছে? 76 days. There is defective, it says 50, but actually 76 days.
Prayer is defective.
Yes,
So
defective
that
means the
your application for condonation of delay has come.
delay and Milord also stay. Delay is delay, Milord, that is the stage, Milord, 50 days, but it should be 15 with 76 days. অর্ডারটা কোথায় রাজশরী মন্ত্র?
2 days left.
কোথায়? আছি না তো। অ্যাপিলটা ফাইল হয়েছে কবে? ডেট অফ ফাইলিং অফ দ্য অ্যাপিল কবে? সার্টিফাইড কপিটা কবে অ্যাপিল? সার্টিফাইড কপিটা আছে জজ সাহেবের কাছে? হ্যাঁ, পেয়েছো কবে? না, পেড আছে।
Yes, what is the matter, Mr.?
Matter is, Milord, that the order, Milord, under appeal, Milord, dated June 13, 2024. If your lordship, Milord, kindly takes pain. Yes, Milord, cost and Milord, also Milord, the learned single judge, Milord, disbelieved, Milord, the documents, Milord, that were produced before the honorable single judge, Milord.
So what was your prayer in the read?
Milord, read, Milord, that is a sequel to the Milord 11. I approached this honorable court, Milord, initially for consideration of my claim of regularization as against the post of a teacher, Milord. I have been rendering my service, Milord, in a primary school, Milord, which is approved, which is a Christian missionary minority school, Milord, within the meaning of, Milord, Rule 30 of the, Milord, the special rules, Milord. Your lordship knows.
Now you are still working?
Yes, I am still working. 2010, Milord, vacancy arose. Now, Milord, my initial appointment was not a backdoor entry. That was in consonance with the two memos, Milord, which I have, Milord, referred. Milord, I approached your lordship's court, Milord, honorable justice.
You have served upon all.
Milord,
I'm for the state only,
but
Milord.
school?
But other is there.
Yes, Milord, the honorable single judge, Milord, if your lordship, Milord, kindly, Milord, 13 June 2024 order.
We will condone your delay and give them an opportunity to use an opposition. We will keep it on the next day. Because
and Milord,
read petition, no affidavit was given.
No, on the first day, Milord, this was dismissed. The learned trial judge, Milord, disbelieved the documents. Milord, I am told, Milord,
Regularization জন্য করতে সেই জন্য ওসব কিছু থাকবে না।
And Milord, the 10,000 rupees cost, Milord, the honorable single judge, Milord, came to a conclusion upon beholding, Milord, this document, Milord.
Mr.
The prima facie,
Yes, which document, Mr.?
Milord,
Your read petition, have you
Milord,
annexed?
my yes, Milord, the resolution, attendance register, everything was disbelieved. Kindly see, Milord.
Read petition, Mr. Basu.
Milord, that is, Milord, the read
Not
petition.
Not
No,
annexed.
I will file, Milord.
Annex তো করবে।
Paragraph 2, stay application.
The honorable single judge, Milord, kindly sees.
Paragraph 2, stay.
School has produced a letter of 17th April 2018.
No. Yeah. I would, Milord, only say that, Milord, the management committee has not constituted any selection committee. There was no advertisement. The honorable, I will address your lordship on merit that the memo says, Milord, there is a categorical statement in the petition that, Milord, in terms of the two memos, Milord, I was called for the interview and I was selected. Now, Milord, the court has seen a copy of the resolution book produced by the state. The impugned order, therefore, does not call for. However, this court is surprised to see the subsequent communication of the management of the school dated 3rd February 2022, 2 years after such and such, where every document appears to have been found There is, however, no document from the school constituting a selection committee. The documents produced along with the writ petition are clearly an afterthought and are most likely manufactured once again. Millard, this is possibly, Millard, subject to correction, Millard, the basic tenets of the Evidence Act 45, section for 73 and 79. If court prima facie, Millard, casts a doubt on a document, Millard, the court should have referred, Millard, to the expert. 45, 73, 79. On the
Service
first
you have done.
সার্ভিস হয়েছে হ্যাঁ তো না সেন্ট বলছেন
না সার্ভিস রিফিউজ সেক্রেটারি
10,000 rupees cost.
We are staying the order. We are staying the direction towards payment of cost, and we will hear the matter. Delay condone করে
My lord,
কিসের জন্য এসছো? মহা মুশকিল করে দিও লোকটা, স্টে করে দিয়ে
to comply with the Lordship's order, I am serving the copy now.
My lord, last occasion I submitted, I have not received the copy of the application.
Yes,
my
I am
lord.
ready
My
to
lord,
copy.
he is supplying just now.
এখন দিচ্ছ?
Yes, on Monday, my lord, I requested them because they told me that before your Lordship, they will take the
No,
copy.
no, no, my lord.
Hey, you are doing your side.
No,
You are doing-
nothing has
you are doing- I am not criticizing anyone. I am not criticizing anyone.
What, you want to go in to
Yes.
look through it?
First time, my lord, I have seen this, my lord. He have not served upon board also.
Restoration.
Restoration,
And on the previous occasion, my lord, your Lordship.
restoration memo and stay application.
644 days.
Yes, my lord, on the previous occasion, my lord, your Lordship forgave me, saying that I shall condone the delay, but I shall not, if your Lordship, if I make any mistake in the appeal, there will be. I remember your Lordship, my lord.
No, what was the order impugned, Mr.
Lord, that I don't know, my lord. First time I have received this, my lord. I could not appear in the before the single bench. না, কোন মামলা এটা?
কিছু নেই।
If your Lordship make it after, after vacation or yes.
Yes, yes, my lord, I appeared before honorable single judge, but I can't remember this, my lord. Fact.
আচ্ছা, just give us 2 minutes.
So far, section 5 is
কোথায় 11? Dismissed for the can, what was can 1?
Section 5, my lord, privacy. I was feeling a sort of phobia, my lord, before coming on Lordship.
Can 1 was dismissed for, section 5 was dismissed for default.
Default, my lord, and application.
Now, on 11th of June,
11th of
when did you file the restoration application?
There is some delay, my lord.
When?
There is some delay.
19th of
After 1 month, my lord, your Lordship. And therefore, my lord, I was feeling a
So
sort of
then
phobia.
they
I am feeling a sort of phobia.
restoration হচ্ছে তো কোথায়?
কি বলবো?
For restoration, you have filed again and section 5 or what?
Yes. Section 5, I have perhaps not filed. As
Your
my
restoration is also belated.
related, my lord. I am admitting that, my lord. And therefore, on the previous occasion, I am coming here with a phobia
For-
before your Lordship.
Are prayer day have you said to condone
There
the
is no
delay?
prayer for condoning the delay in the restoration.
Yes, my lord, yes, yeah, that I am not filed. And if you direct me, and I shall file, my lord. Hey, file the copy.
কত ফাইল করবে? কত জুন?
19th of
We are restoring. I mean,
My lord, kindly do not record my consent.
now we will say we were dismissing, you said that you allow.
Oh, Lordship is possible.
Grateful.
the appeal and the application were dismissed on 11th June 20.
of Teacher Education. My lord, I'm filing an affidavit on her behalf, and my lord, I'm praying for 2 weeks time after vacation.
You will file the affidavit today and you will pay
Affidavit
for
filed
time.
by the yes.
On 19th of May 2025,
There
the
was an
petitioner was
instruction.
pleased to ask for a report indicating certain points. Now, they asked for extension of time that was allowed by this honorable bench, and ultimately, my lord, they are filing the same today. They have already handed over a copy to us, but I have gone through the same. It shows that there was a query by this court whether NCTE took any decision not to apply online for registration of B.Ed colleges. The answer is in context of above, the NCTE states that there is no decision taken for non-inviting any application through online. Now, there was another query whether the regulation 2014 that was suspended by the NCTE. They said no. Even then, what they did since 2022, they are not opening the portal, enabling the intending institutes to apply for setting up or for recognition of any B.Ed college. That is under challenge before Lordship. Because we are the DLED college, we have the infrastructure to have B.Ed. We need to apply. It should be through portal.
Portal is not opening.
The portal is, my lord, that is closed since 2022. And in writ petition, one stand, affidavit filed in this, my lord, appeal, another stand, and today the third stand is coming.
Which order? May?
Yes, my lord, 19th May 2025. Passed by coordinating bench.
No application was protest from 2019 to 20. What is their answer?
Is they say yes, we did not. We didn't open the portal without having any resolution or decision of the NCTE itself.
Why they are not inviting?
But they said a new policy has already been introduced, but that is yet to be worked out. And taking that plea, that stopped since 2020. Present status, they said.
They say they have annexed a 27th May memo, public notice, inviting online application for academic session 26-27.
That is in respect of, my lord, ITEP. This is another course. It's Integrated Teacher Education Program.
Then what is your course?
Only B.Ed.
No, then what is their explanation given?
They said, well, kindly have a look. Internal page 5.3. The appellant has not included the curriculum that was the observation of the division bench in its syllabus, although it appears that on 14th July 2022, a decision was taken for opening all portal for inviting fresh application. Till date, the online portal has not been opened. This process cannot go indefinitely as it would vitally affect the aspirants from the obtaining B.Ed degree.
So you are not what your ITEP was not in the curriculum.
No.
So you cannot be recognized as an ITEP ITEP.
Because we are the DLED course. Now we want B.Ed. They said now by 2025 there is a process for DLED to B.Ed. They enter by a common platform. That is their motto. But they didn't allow us to make any application. And if your lordship's explanation at page 5, the next point, as stated in reply point number so and so above, the general body of the council in its 55th meeting held on 14th of July 2022 unanimously decided that the portal for inviting fresh applications should not be open till formulation of revised norms circular so and so in connection 2020 NEP of the new education policy. Further, the general body of the council in its 63rd meeting held on 19th March 2025 approved the draft NCTE regulation 2025 in respect of the following 9 courses aligned with the new education policy 2020. However, the same are at present in discussion stage.
So if this is allowed, sorry.
Mr. Jahan, we can't understand. Paragraph 3 says that on 14 July, a decision was taken for opening all portals.
Yes.
And the very next paragraph, they are saying that on 14 July 22, unanimous decided portal for inviting should not be opened.
They decided for asking for application, but it is closed.
Now, these 9 courses where it is given, does it include your, do you come within those 9 norms? Page 5, internal page 5.
Bachelor of Education program, 2 years leading to Bachelor Education. Yes, that's there.
Bachelor of Education.
That's there, 6.
Yes,
6 is there, my lord. Clause 6.
Yes, you are there in.
Yes, you are there.
All the 14.
But this says this is at the discussion stage at present.
14 it is
not open.
Enjoying the read. Allow the read.
Same meeting. Same meeting. Should
not be open.
And your lordship is surprised if your lordship takes up internal page 2.
মার্চে ওটা খুলে দিয়েছে for 9 courses. Further, general body is approved. The draft NCT regulation in respect of following.
Stage. However,
But I request your lordships to come to point number 1 once.
Just at present in discussion stage.
এখনো খুলেনি. As a steps taken for in terms of minutes of 14 published in the Gazette are at present in force in the notification published in October. The invited online application for ITEP 4 times since then.
My lord, I seek indulgence to appear online, my lord, because I could not go to court today because of my sickness. If I can be allowed to make some submissions online, lordship, for today only.
You get well and come before us. Because we don't understand anything from the report which has been filed.
Lordship, the affidavit, if lordship allows me, I can sum up in few sentences. It is prepared by me as per their instructions. I have given copy to them.
We'll keep it on.
Lordship, I have given copy to them earlier, also 2-3 days earlier. So,
such and such London advocate appearing for
NCTE, I appear.
NCTE online files the affidavit as called for earlier by a coordinate bench of this court. Stop. Let the said affidavit be kept on record. Stop. A copy of the said affidavit has been handed over to Mr. Jahan, learned advocate appearing for the appellant in court today.
So it was given 2 days earlier, lordship. It was given 2 days earlier.
16th we got it.
Handed over to Mr. Handed
2
over
days ago.
on Mr. Jahan on 16th.
16th.
Stop. He pressed for leave to file an exception to the said report. Stop. Let such exception be filed within 31st October.
Yes, ma'am.
Within 31st October 2025 with a copy to the learned advocate on record of NCTE. Stop. The matter for further consideration on 11th November, or at least the matter on 6th November.
Great.
Yes.
Grateful.
Extremely good.
See if you can.
Grateful, lordship. Grateful, lordship.
Item
I'm
number 12,
appearing
my
for
lord,
university.
money appeal, my lord. My lord, last occasion.
My lord, I
matter
appeal
was-
for the writ petitioner, respondent number 1 and
Yes, my lord. Yes.
I'm
Last
appealing for the
oc-
respondent.
Last occasion, my lord, when the matter was taken up by your lordship, my lord, I submitted, and thereafter Mr. State Advocate also submitted, and my lord, he was in virtual mode. As a result, your lordship was pleased to direct him to be present here. For this reason, matter is fixed. Matter is relating to the redesignation of the petitioner, my lord. Matter is relating to the promotion, redesignation of the petitioner in the Kalani University from a teaching cadre to non-teaching cadre. My lord, your lordship knows that, my lord, in university system throughout the West Bengal, there are two types of cadre, my lord, teaching and non-teaching. Petitioner, my lord, cadre cannot be changed, my lord. So, my lord, petitioner's cadre was changed. So, university cannot do that. Thereafter, subsequently, university changed his wrong. And thereafter, my lord, it was sent to the higher education department for his approval. My lord, Honorable single judge hold that, my lord, cadre is nothing. Petitioner is in the teaching post. Throughout it is wrong, my lord. I can demonstrate from my document. My lord, 1 minute, my lord. From my document, I will so, my lord. In this situation, after hearing all the parties, my lord, Honorable Coordinate Bench was pleased to direct the state to file a report.
File a report.
Yes, my lord. Because what is the answer of state response?
What do you want today?
My lord, I want, my lord, state has submitted his report. And my lord, your lordship, I am accepting the state's report. If your lordship passes order accepting the state reports as per coordinate bench.
We have already accepted. Earlier order, we have already accepted the report.
Then, my lord, kindly it may be disposed of according to the state's report. My lord.
Because my lord, without obtaining any concurrence from the state, my lord, everything was done.
well, similar candidates
That cannot
be approached before this honorable court. Well, my submission, my lord, this appeal, my lord, has been, my lord, similar appeal has been disposed of by the honorable division bench. My lord, there, my lord, the
Division
action of
bench
the,
appeal disposed of?
yes,
Where
another
is-
appeal.
Where is the order? Have you got it?
Now, my lord, it went up to the Supreme Court, my lord. My lord, honorable Supreme Court also affirmed the order. Only modified to the extent, my lord, there was a 10% interest imposed on the financial liability of the university. There, my lord, the interest was removed. That part
Then
was
you do one thing. You have got the report.
report I have got.
So you
But they
use
have
a,
given a contradiction.
you use an exception to the report, bringing on record this earlier order which was passed in a similar matter and the order of the Supreme Court. And we will finish it off then.
My lord,
my lord, scientist.
Absolutely, my lord,
my lord, so far,
same post.
My lord, scientific
may I
officer
submit one
went
thing?
to professor.
My lord, may I submit one thing, my
Scientific
lord?
officer went to professor.
My lord, may I submit one thing, my lord? In
Can I be done?
That has been done, my lord, in view of the UGC scheme.
My lord, may I submit one thing, my lord? Subject to kind. My lord, in that matter, I appeared, being led by Mr.
My
Lokhi
learned friend appeared.
being led by Mr. Lokhi Kumar Gupta, I appeared in that matter. My lord, my understanding, my humble understanding is this, my lord, matter is not similar. So, my lord, I can want a chance, my lord, so that there is, I know there cannot be exception, but I want to deal with that, my lord, because matters are not similar, my lord.
Just now you said we decided as per report. Now you are, since we have asked him
If
to,
he
you are-
files, my lord, something, then I have to contravene it, my lord.
What?
Because law points are involved, my lord.
Exception to
Let him
kindly, my lord.
submissions to my
You
exception.
file the report, you file the exception to the report, give an advance copy to him, also to Mr. Devra. We will hear the matter. We will hear him as to what he has to say as regards that order. And if he wants to file a report exception to the said exception, then we will consider.
My lord, I'm grateful, my lord.
Only
Deeply
the
obliged.
order is required. If you are satisfied, point is covered, we will dispose it of it.
Deeply obliged.
Mr. Learned advocate appearing for the respondent numbers 1 and 2. Mr. Haldar. Mr. Haldar, learned advocate appearing for the respondent numbers 1 and 2. Prays for leave to file an exception to the report filed on behalf of the respondent number 3.
See, I have straight over.
Report ta to
I have three, yes.
such prayer. Let such exception be filed within a week.
I'm grateful, my lord.
happy.
সবাই happy.
পুজোর আগে
Grateful, my lord.
পুজোর আগে everybody happy.
We have discussed
transfer, but he has been trying since 2018 through offline mode initially. Now, in between this portal came, he applied through portal, NOC from the managing committee. Now, my lord, DI returned it back with an endorsement. Single teacher is not permissible. I move the first writ petition, direction to follow the particular circular. 1 second rejection. The second writ petition also decided in my favor. Then, my lord, the last rejection showing the same ground, we are not getting any alternative teacher to work in your place. That's the reason we cannot allow you. Now, my lord, my third writ petition that has been dismissed, and say, let the authority make an attempt to find out someone.
Yes, Mr. Government Pleader, we have
But
considered
this is your
this
lordship's division bench order covering this issue.
This circular says that you have to make a local arrangement and you have to find out a teacher and forward it to the director, then to the commissioner, then the transfer will be considered. The single judge passed an order earlier that unless you find a willing teacher, you will not be able to. So that was appealed against, went before Justice Standard. His Lordship said that willing teacher, this thing is not there in the circular. You have to take the decision. So we followed that decision and we considered and we modified the orders. Next time what happened, Another matter came, Mr. Vivekananda Bose was appearing. I said that this problem has to be solved. Unless suppose 3 teachers are there. Now, nobody will be willing to leave his place and go to another school. So there must be some sort of incentive to be given, or some sort of, what should I say, just we eulogize the service that you have done for the administration. Unless you give any sort of incentive to this person, why he will come? So we told that you speak with the government authorities, but that matter also not done.
Lordship, just 10 minutes before I talk with the Principal Secretary of Education Department, day after tomorrow I will sit regarding this matter. Because the single teacher, the problem is that the single teacher, if the single teacher is transferred, suppose in a class 100 students for the physics subject. At that moment, that teacher is transferred from another school. The student will suffer.
Yes, then you divide it specifically.
Lordship.
Why do you say that single teacher school will not reject? It will be given to the DI. DI will make a local arrangement so that.
There are 3 or 4 division judgment, Lordship, in this
Yes,
regard.
we have considered. We have
kindly take up the matter on Monday. Day after tomorrow, I will sit with the Principal Secretary of Education Department. Give me one chance.
able to give any solution.
Lordship, give me one chance, Lordship. Give me one chance.
Mr. Let us tell you, all the judgments have been considered by us. This willing, you will not find this word in the circular of 3rd January.
22 circular is
Now,
not.
it is repeatedly being argued before us that it is a single teacher, 100 students. We appreciate that 100 students are there. How can a single teacher be sent out? But your government says that he has sent him out. And my DI will find out a particular person to do that person's job, so that till the finally a further recommendation is made. So these are time consuming things.
The Monday it will be solved. I hope that Monday it will be solved.
Now what the DIs are doing, I tell you, the government advocates are also helpless. What the DI is doing, DI after this order is passed, write 5 letters to all the surrounding.
All these.
And finishes his job. No reply given, I cannot make. But then your circular becomes infructuous. Thousands of litigations we are giving rise to. Then you revoke the circular of 3rd January. That no, we have reconsidered the matter. This is a fresh circular, and you will be surprised. Matters are pending since 2019 application, 20 application.
It's of 2018.
18
has been suffering.
That is Women's judgment, the 5 years. The matter has been pending.
5 years. So mentioned judgment we considered Horistanand judgment. We also passed an order.
More than 5 years, all the applications are pending.
Then what? Then
kindly take up the matter on Monday. In the meantime, I will sort out the problem.
You tell your DI, because the circular says DI is the first local arrangement. DI will, maybe the teacher will not be willing. Maybe the teacher, but the teacher, then the DI has to mention the name of the teacher, mention the name of the school where he is working, and then he has to send it to the director. Then the commissioner will take, commissioner.
The problem is what will.
That is not there. Mr. Rai, we pass our order. You take up the matter with the secretary, and there are future litigations also. Here, house.
Affidavit of service.
अभी तो चलते मैटर ऑर्डर पास ऑर्डर कॉपी दीजिए
এটা নয় দিয়ে চলে
You are a teacher of what? Which subject?
Physics মানে
Assistant teacher of physics.
Physics.
Under science group, what is the name of the school?
ধৈর্য নারায়ণ
Respondent number কি বল?
Respondent number মানে 4
মানে 10 and 11
respondent number 10 and 11 Dhoriyo Narayan High School.
যশোর রাইটলি বলছে কেন কেন স্কুল চেঞ্জ করতে হবে?
You are the district inspector of which division?
Kuchbihar.
কারেকশন করেছি এখানে ঠিক আছে, যে এইটার বদলে এই পোর্শনটা প্লেস করবে অর্ডারের, এই যে এখান থেকে এতটা, ঠিক আছে। আর স্কুলের নামটা দেখে ফার্স্ট প্যারাগ্রাফ Yes. You know, not only. How to what to গতকালের মামলাটা এটা।
Lord, the matter is, Lord, Lord.
I'm opposing, strongly opposing.
Matter is hearing matter. One thing is hearing matter. Another thing is this, there is, Lord, paper book. And third thing is, there is paper book, Lord. I have already filed, but paper book has not been come to your lordship's court, Lord. And third thing is, my senior is, Lord, telling me that matter is, Lord, should be posted.
But I'm
after
suffering from an
vacation,
interim
Lord,
order
so that,
since 2024, 2022.
and Lord, another thing is
I'm
this,
out of pension, provident fund, gratuity, nothing has been given.
another thing is this, Lord, your lordship directed me to serve the copy upon the, Lord, school concern. I have served the copy on the returnable date, Lord. Schools authority were come to the court, Lord, but your lordships not taken up the matter. That's why they have returned to the home, Lord.
Well, at least I'll direct them to release my provident fund because I'm out.
Without hearing cannot be, Lord.
Then not kindly hear out the matter. If
my
it is
my
kindly hear the matter. But I'm ready with it.
It will take time, Lord.
A little take time. We have
it is my submission before the court.
No, why you are so hesitant? Who is your senior?
Lord, Bishoprodha Basmulli. Bishoprodha Basmulli.
Bishoprodha Basmulli.
Last
So why
occasion,
he is not arguing?
Lord, he is, Lord, last occasion on.
If you have a bad case, you have to.
No, I have no
what
bad
can
case,
be
Lord,
done?
at all. No, Lord. I am
this way a person is without his dues. If you delay the proceeding this manner,
I
it
am not
becomes
delaying, Lord.
embarrassing
I am
for
not a single date, Lord. I am not any paying adjournment or.
Today also you are praying. You started saying I am
paying for only this reason, Lord, not
So
in
you
other.
very well know that if we make this prayer, court will keep it after vacation. You again get a
No,
trigger
Lord.
for
You will also kindly fix a date and time pump bound manner, I shall further indicate to the person, those who are intent to, Lord, take participate in the court process.
not required. If they do not come, what will be
No,
done?
Lord, they, Lord, as you lost, I am not.
There are
I'm only
human
seeking,
considerations also. Either if you want to stop him at this stage. Don't keep him under a false hope that High Court is considering.
No, my Lord, I am not. I am just. And my Lord, paper book was there.
What was the issue about interim order for provisional pension was granted?
Yes.
So provisional pension also has not been paid. Why? What is their reason?
No, alleging that I obtained the job by producing a false school leaving certificate. No departmental proceedings initiated against me till my retirement. But I prefer a writ petition challenging the steps taken by the DI, by directing me not to attend the school. This honorable court, the honorable single bench of this honorable court, please to stay out of the DI and directed me to join my duties. I joined, continue it. Thereafter, I retired.
Which year you retired?
I retired 2016.
16 you retired?
Yes, my lord. Thereafter, I filed a writ petition. All the writ petition disposed of by a common judgment of this honorable court, honorable single bench. Single bench directed,
All
pay
the
him.
writ petitions means
There are 4 writ petitions.
4 persons are here.
No, only one person, but the writ petitioner were 4.
Oh, writ petitioners were.
Writ petitioners one writ petitioner, 4 writ petition.
Oh, there is 4 writ petitions.
Yes.
They were taken up together.
They are taken up together.
Very good.
And by a common judgment and order, impugned before your lordship, the honorable single bench pleased to allow all the writ petition, thereby directing to pay all my retail dues, including the provisional pension, since a criminal case was pending against me. After filing of this appeal, the criminal case also caused by this honorable court.
Pardon?
Since a criminal case was pending against me, the honorable single bench directed to pay me the provisional pension. During the pendency of the appeal,
Now criminal case disposed of.
quashed by this honorable court.
Then what is your ground, Mr. Das?
My lord, the ground is there, my lord. The documents, he says that his client is, my lord, superannuated. But there is, my lord, 2 documents provided in the writ petition annexing those documents that in a place his date of birth is other thing and another place his date of birth is another thing. So, my lord, your lordship is asking me to serve the copy upon the school concerned. In 2 school, my lord, they produced the document and, my lord, got the appointment as a group C or group D staff in a school, my lord, class 8 pass. But he is not a class 8 pass student, my lord.
Point is whether there was disciplinary proceeding.
Yes, my lord. Disciplinary proceeding was initiated and, my lord, again and again, my lord, he filed a case, writ petition.
Ultimately, he was allowed
total,
to
my lord, if I count, my lord, there are 17 petitions filed before the court of law by the petitioner itself. One is, my lord, now last occasion, my lord, 4 writ petition was heard analogously.
tell us he was allowed to join since he was prevented by the authorities to join. Court said that you allow him to join since no proceeding has been initiated. Maybe.
Yes, that is the order.
Was that order challenged?
First order was, my lord, Justice, Honorable Justice Devashish Kargut was then was, my lord, passed the order that you pass a rescind order directed to the DI concern. DI concern passed the order and, my lord, ADI, my lord, report submitted to the concerned DI. In the said report, it was reveals that he has not produced the document. It was required to submit the document whether
We are beating about the bush. We are asking you one question. After that disciplinary proceeding not initiated, allow him to join. This order of the writ court was challenged by you. This was not challenged. So can you
one thing is, my lord, he challenged the order of the passed by the DI concern. And subsequently he passed another order whether when the court is passed to the order to the DPPG for giving the pension. Both the order has been challenged. Subsequently, my lord, in a 4 writ petition, the matter was heard analogously by Justice Honorable Justice Saugata Bhattacharya. And on the said, my lord, judgment, this present appeal is preferred.
So we are asking you a question.
Yes.
That if he has produced a fake certificate, there must have been a proceeding against him.
2 proceedings is this. He has not produced the original document.
Then argue when you know you argue.
I want to argue from the paper book that paper book is not before your lordship.
So we will paper book আছে নি আমাদের?
And that is
Argue we directed to serve, we kept it. Person will die by the time you will get the order.
my lord, as your lordship's direction will have served the copy upon them, my lord.
Matter was fixed at 2 p.m. on 11th. Matter was fixed 2 p.m. on 11th. But due 11th of this month, September. But due to the paucity of time, the matter could not be taken up. That's why the matter is running.
How paucity of time? There must have been.
Another 2 p.m. matter was fixed on that day.
Board versus Priyanka Noskar matter was there.
There's another 2 p.m. matter was fixed on that day. That's why it matter could not be taken up. Well, at least let them pay some provident fund on gratuity.
How can I do, sir?
Because all my learned senior friends shows that single document initiating
Mr.
department.
Ghosh, have you preferred any contempt application?
Yes. That is why they have obtained the stay.
There has been a stay.
Yes.
Oh.
Since there is a contempt application against them. And they are enjoying the stay since 2020. Even you will also kindly see the orders passed by the coordinate benches.
Line application for vacating the stay.
Coordinate bench, my lord, time and again. Even it was the case. Even these writ petitioner given them a concession for filing other appeals.
What has given that? We are upon a false document appointed in a school and take home salary or any other thing should be given by the government exchequer. That cannot be tolerated.
Yes, filed rule was issued at that point of time. They filed an appeal and obtained a stay.
When was the stay obtained?
In its order was passed. May I give you the exact date? 2nd January 2023.
2nd
January 2023.
23.
23.
পেপারটা তুমি আনতে
Then Lordship, led by Mr. Firdaus Samin. In this matter, Lordship, we need some instruction from our client. For that reason, I'm paying for notice week.
1 week after the vacation. What are the CAN applications?
Can for stay, my lord.
Stay and others
Stay
for
of the-
section 5.
Section 5 is also there.
Section কত দিনের delay? You are for the respondent.
I am for the still respondent.
1 week after the vacation. Yes, next. Appellant.
There is a restoration application and section 5. There is a affidavit of service.
How many days?
131 days.
What? Mr.
Matter may be hard in merit, my lord. I am not opposing that restoration.
What? Higher scale of pay?
It's a regularization matter. My lord, the prayer of the petitioner has been rejected on the twofold ground. Number one ground,
paper book,
white publication is not there. And number two, there is no information to the employment exchange to send candidates to participate in the interview. My lord, we are the candidate. We are selected. We are given the appointment. We have came to know our fate when our case has our fixation.
56 of the paper book, my lord, order of the impugned.
My lord, my prayer before your lordship, kindly allow the restoration application and come back with some judgments to do a research work and come back with some judgment after vacation, if possible, my lord.
It is a
restoration and section 5.
Restoration of by which order it was dismissed?
My lord.
Section 5 in filing restoration?
Restoration.
Oh,
my lord, it is July 15, 2024. July 15, 2024.
December 20.
I appear on behalf of the appellant. Lordship, my learned junior, I come to learn that he has given a notice to the other side. That is on record. But one thing I should say, my lord, that there has been a bereavement in my family.
Oh, yes, yes.
That's the reason that will be done tomorrow and day after tomorrow.
Yes, yes.
Therefore, kindly take it any day in the next
You
week
are
if it's.
all right.
I'm all right, but we are with a heavy heart.
Naturally.
I tried my best.
After the vacation.
I leave it to my lords. Only thing is expressing the agony that your lordship indicated that in a house he wants that there should be construction of the grills.
Yes, we remember. We remember.
But-
Mustafa, Mr. Mustafa.
We'll take it.
So we keep it on the reopening date. Hearing. All right, you people are appearing.
24.
For the applicant.
For the
Paper book file.
He's on legs on courtroom number 14. My lord, kindly grants a short passover, my lord.
Password কি করব?
Or it's a hearing matter, my lord.
চলো after vacation করব।
My lord, my lord keeps in on Monday, my lord. My lord.
Sir, it won't be reached. The next Thursday রেখে দাও. Let it be.
Great.
Grateful.
I am appearing for the UGC.
You are appearing, Mr.
Yes.
University Grant Commission, my lord.
You are for?
I'm for the institute, Appellant Institute.
What was the matter about?
Termination.
Oh,
It's not that matter, my lord. That is fixed on 22nd.
no, that we know.
But the same institution.
Same institute.
Same institution. Grateful, ma'am.
My lord, next Thursday. Grateful. Next Thursday. Grateful.
You ordered to follow. Good.
In this matter, I am appearing for the appellant.
I am appearing for the respondent number 2.
On last occasion,
Why should
On the 20th August, Your Lordship pleased to pass an order to the effect directing me to serve the order passed by Lordship, thereby intimating them that the matter will be taken up for hearing.
He has got
If
the
the
information.
further chance.
I am
Not
appearing
have
for
some
the
copy.
State Project Director, Poschimbango Samagro Shikha Mission. State, on the last occasion, State did not appear. আপনি স্যার
Oh, acha.
কোনো কেউ করছে না কেন? তুমি বসে আছে তো।
Why they are not appearing?
They have got nothing to say.
You are there? Naki?
বলতে পারো তো টেকা পারো।
No, no.
So what do you want? You don't want to do it today.
I'm ready. If Your Lordship please to direct me so that I can press my case. And if
Yes,
Your Lordship
then-
please to adjourn the matter.
may I
so
be permitted to file?
Because my lord, certain development was there.
We are not adjourning.
No. There's a certain development was there. On other question during
You
hearing,
gave a supplementary evidence.
I think supplementary evidence, if Your
Yes,
Lordship.
you have filed a supplementary.
Yes. But during hearing on last occasion, Your Lordship pleased to ask me some question. Number one, why there was delay in filing the writ petition? Because the panel in question, which is under challenge before Lordship, my lord, it was passed in the year 2004. And the writ petition was filed in 2007. So Your Lordship pleased to ask me why there was delay. So I have got the copy from which it will be shown before Lordship, my lord, that why the delay was there. Because challenging that selection process, one application was filed, suit was filed before the landed court below.
Then you place na. You place the matter.
Now, I can place all the with supplementary affidavit or plain copy. If Your Lordship, please, I will ready.
Supplementary you have served.
No. Unless Your Lordship please to direct me to file supplementary affidavit annexing
No,
all the
that-
subsequent development.
Hey, again supplementary. কতবার supplementary?
Because my lord, after hearing Your Lordship please to ask me some questions. In respect of that question, my lord, I want
So
to say
that liberty we gave to you on 20th August.
Because yes, and pursuant to that direction, we filed supplementary affidavit.
You filed.
Yes, that's supplementary affidavit. But subsequently,
আরো কিছু জানতে পারছি। এটা 12th August ফাইল করলো। 20
আবার
August
কি how many
না,
supplementaries?
বলছে এইটার পরে ফার্দার অপারেশন টু এটা থেকে আমরা বললাম সাপ্লিমেন্টারি ফাইল করা
এটা তো ফাইলটা রেকর্ডে দিলাম।
এখন আরেকটা ফাইল
Then you intimated to the school.
everybody.
Mr. Mukherjee, you are for whom?
Well, I am appearing for respondent number 2, State Project Director, Poschimbango Samagro Shikha Mission. The state, my lord, the district project officer, he, my lord, filed an affidavit before the learned single judge. That was not before your lordship. That is why my learned senior friend, my lord, filed the supplementary affidavit.
Yes.
Now, my lord, all the pleadings, my lord, which were placed before the learned single judge, before your lordship. Now, only one thing, my lord, it was an ex parte order. My lord, if your lordship kindly grants me leave, my lord, to file an affidavit in opposition in connection with the stay as well as the supplementary affidavit, because there are, my lord, in 2010, the entire policy has been changed by the Education Department, State of West Bengal. So there are notifications.
You did not use an affidavit before the learned
The state filed an affidavit in opposition, but
you did not. The respondent number 2, you
no, I do not, my lord. Perhaps, my lord, we were not served, my lord, at the relevant point of time. SPD was not served. Respondent number 2 was not served.
The opposition দিয়েছিল তো আপনারা দিয়েছিলেন।
না, DPO দিয়েছিল।
DPO টা answering respondent is the DPO, na?
District Project Officer.
No, you are not appearing for it.
Well, no, well, perhaps, my lord, the Poschimbango Samagro Shikha Mission was not served.
Everybody was served during hearing, none appears, my lord.
You are appearing for the respondent number 2.
Yes, my lord. The district project officer, my lord, implements the policy, my lord, adopted by this respondent number 2, Poschimbango
Who
Samagro
appears
Shikha
for the state district project officer? Do you know? Anybody entered appearance?
No, nobody appeared. Even the school authority was served, they also did not appear in the hearing, my lord.
Now the DPO's order was under challenge.
Yes.
DPO order under challenge.
এরা পলিসিটা
পলিসি ডিসাইড করে
এক্সিকিউট করো তো কি কে আর তুলে দেবো So can you give a set of documents to Mr. Chattopadhyay? We will ask the state to appear there. Mr. Chattopadhyay. Go down. This is, he will give you all the copies. We will engage you on behalf of the state with Mr. Das.
But tomorrow I shall, sir. Because I have got my
Give it tomorrow. We are keeping it on 28th October.
I shall have copy. I shall have copy my land.
Can you file that supplementary within 1 week?
Yes.
Huh?
Yes.
So you file the supplementary within 1 week. We are engaging him. You give all the documents to him because nobody is here for DPO whose order you have challenged, though he is appeared. Right na?
I'm for the appellant.
What is the matter, Mr. Jha?
It was hard. Previously, the petitioner obtained physical education, MPA.
Oh,
From-
Mr. Chattopadhyay, is it covered?
I
We have
I
kept
tell you,
matters on.
the DI has taken two grounds. On grounds, I obtained degree from Nagpur University in summer vacation course. Another, the staff pattern. Summer vacation course, learned single judge, set aside that order. Directed the DI to pass it in order considering the staff pattern. I have come up with an appeal that the staff pattern is not applicable in the case of physical education teacher, because in the staff pattern there is no category, there is no distinction between honors or postgraduate or postgraduate. There is a judgment of this honorable court, honorable division bench judgment, single bench judgment, my lords sitting singly passed an order. I will place. My last occasion, my lords was
Shefali Jana.
No, Shefali Jana CPFG.
Boishali Banerjee, that has been upheld by the honorable special bench also. Boishali Banerjee on the point that the physical educations after amendment of ROPA 98, thereafter amendment in the case of honors and postgraduate category, physical education will be treated as similar footing. That physical education teacher obtain postgraduate degree is entitled. Even there is 3 teachers are entitled, 3 teachers will be eligible. Because there is no distinctions between past graduate or honors graduate. Because there is no honors degree in physical bachelor education or master. I will place the last occasion, my lords, please kindly the first impugn.
Last occasion, your lordship, after hearing your lordship directed to serve
I have
upon the school.
I have sir, but this is not the issue. My lord, just my lord, I
Mr.
have.
Jana, we have kept we matter to cover. We have kept
23rd, I have told
23rd কি আমার মনে পড়ছে না 23rd therein one set of advocates were appearing. So Utpal Karan was placed.
Yes.
So the state he in his fairness submitted that Utpal Karan covers the matter.
Yes.
Next day we heard another matter similar to yours. Hard means he was arguing state's appeal. So I said that state appearing in item 4 is saying that it is covered. You are saying it is not covered.
Utpal Karan is covered also.
He was making a fresh argument. So I said that there is no utility. There has to be a common stand. If the state agrees in one matter, then it's not a problem. Then we keep it on 23rd along with that matter.
According to my lord, it has been settled. Now MPA my lord entitled to higher scale. In my view, my lord.
And in my case, the previous honorable division bench directed the DI to grant postgraduate scale of pay. DI has sanctioned. I moved a writ petition. The honorable single judge directed to give the benefit in terms of the sanction order. State has preferred an appeal. Now the honorable division bench said that the consider the staff pattern. Now that has been considered. DI has rejected my case. That forget the bypassing the staff pattern. They said I have obtained the degree.
Mr. Jana, there was another circular for physical education. Staff pattern is not required.
Not applicable. That I have also the entire the compilation I have brought it.
Please give us that compilation.
Yeah, way to this.
দিয়ে দিচ্ছি নিয়ে এসছি সবই নিয়ে এসছি
ওইগুলো কি অ্যাপ্লিকেশনে
and 182, if I remember correctly.
182.
Of the Utpal Kanti.
Utpal Kanti Karan. 182, past graduate teacher will not be entitled to, but the past graduate teacher not entitled according to ROPA, amendment of ROPA, that has been amended by 2002. There is a segregation, two categories, one past graduate, another honors and or postgraduate. But in the case of physical education teacher, the 735 in 2002 circular, that has not been amended. But this honorable
I passed an order singly.
Vaishali Banerjee, entire has been discussed by the honorable division. That has been upheld by the Utpal Kanti Court. This is the judgment of the.
Give my order.
Only the my lord's order, yes. এই দুটো জজ সাহেবের order.
This was complied or
complied. No appeal has been paid. Will also kindly wanted to consider the Vaishali Banerjee. That has been discussed why the physical education teacher is entitled even after the amendment of ROPA.
Utpal Kanti was only in respect of physical education or
no. Utpal Kanti was only in respect of past graduate and honors or postgraduate. That is the issue framed by the
argument was advanced that career advancement and
ROPA. That I have compilations, ROPA 98 onwards amendment I have been giving.
Utpal Kanti Karan mainly whether prior permission is necessary or not. That is the paragraph 177G, that those teachers who has already enrolled before entering into service, they will get the benefit.
That permission is there.
177 paragraph G specifically observed, those teachers has already enrolled before entering into service, they are entitled to higher pay scale.
177
small g.
And then what happens to persons who acquired thereafter?
Thereafter, the prior permission necessary according to 2005 Act.
Then
Control of
Justice
expenditure.
The past Asadul Chaudhary
That all has been covered. Considered
Hussain Chaudhary,
covered.
Who
yes, all has been discussed.
fought for permission, but the DI has remained silent.
Mere silence is Akhtar Hossain's mere silence is accepted. That is the view of the Justice Prabhu Chattopadhyay, Division Bench.
What is accepted?
Mere silence. DI petitioner.
Mere silence, right?
Is acceptance. That is the observation.
And that circular where prior permission was required, his lordship says that is for doing it in
correspondence. That is 96 circulars. The kindly page 5 of the compilation, the career advancement scheme. 12.
Page 5.
Page 5 of my compilation. Not list of it. 12.3.
Yes. All teachers
including physical education teachers and librarian of secondary school who have will improve their qualifications, who were appointed with higher qualification in the subjects of the relevant to their teaching appointments shall get higher scale of pay appropriate to their qualifications with effect from 1st January 1996 or the date of improving qualification, whichever is later. This is the
ROPA.
ROPA 90.
ROPA
90.
This has been closed. This clause has been amended in 1999. Though the DI in my impugn order that this amendment on page 7, 13 July is not applicable to you.
Not applicable to you. Why?
The DI said, can you see the impugn order? Specific.
What was the reason? Why not applicable?
Simply, my lord,
you place the amendment?
Yes, amendment, page 7. My lord, the 3. All teachers, including physical education teachers and librarians of secondary schools, who have will improve their qualification or who are appointed with higher qualification in the subjects or group relevant to their teaching appointment shall get higher scale of pay appropriate to their qualifications with effect from 1st January 1996 or the date of improving qualification, whichever is later. Provided this has been inserted, not amendment. This has been inserted. Provided that such higher qualified teachers in the relevant subject or group is justified as per approved staff pattern of that school. If such teacher is appointed through West Bengal School Service Commission, his or her pay will be fixed in the scale of pay as per his or her qualification mentioned by the School Service Commission. This has been added. These 3 lines has been added. So, my lord,
please read another. Provided that such higher quality in the relevant subjects or group is justified as per the approved staff pattern of that school.
That is the two.
And if such is appointed, his pays.
Two conditions. One, my lord, justify the staff pattern. Another, my lord, the recommendation through School Service Commission, which qualification mentioned, that pay will be fixed on the basis of qualification mentioned in the recommendation. This is the 2 condition has been added. Now, your lordship, my lord, this is staff pattern. I have just next prior to, my lord, another amendment. Your lordship, kindly the staff pattern, page 10.
This was amended.
No, this is the staff pattern. Staff pattern has not been amended.
No, staff pattern is not required in respect of physical education.
That is my submission, page 10. That is why I am placing page 10. Your lordship, page 10. My single judge, my lord, refer the matter again to the DI to consider on the basis of staff pattern. That is why, my lord, I have come with
So, page 10.
Page 10. Your lordship, kindly see. That
yours is a high school.
High school. Yes. My lord, this is the, my lord, 4th September 1998. D 2
D
1D, no, 2D. 2D for high school, high madrasa, higher secondary school, normal section. D, work education, physical and social service.
2 posts.
2 posts.
They must be having
they must be having qualification as mentioned in the procedure 14 AC dated 8 January 1998. That is the, my lord, the recruitment procedure for selection by the School Service Commission. That is also I have annexed in my list of date. That circular I have enclosed.
Page.
That has not been paginated, my lord.
8th of January 98.
8th of January 98. Yes, your lordship, that is the, my lord, the qualification prescribed for physical education.
Physical education.
What education? Up to 16 716.
Where is that?
Page 716 D.
This has been, my lord, the melody from the school.
Assistant teacher of higher secondary school.
No. 716 G, capital G. Page.
At the corner, my lord.
Oh, capital. Capital.
Assistant on the bottom, my lord.
At the bottom.
Yes.
Assistant teacher in physical education. Method of recruitment. Your lordship, my lord, the qualification next page.
Bachelor with
bachelor degree with degree or diploma in physical education from any recognized university. So there is no category of pass or honors. Only one.
Was in respect of other teachers.
Other teachers, my lord, your lordship, kindly see.
Work education also same.
Work education is also same. There is
that
no.
Is H.
Bachelor degree with postgraduate. No. Assistant teacher in work education.
Bachelor degree with postgraduate basic training or bachelor degree with work education as well. There are also no postgraduate.
No category.
But work education, no.
Or others, my lord, there is also staff pattern you will also will find. There is a category, two categories. One pass category.
So your contention is 90 in the staff pattern circular, work education, they must be having qualification as per 98 circular.
Circular to participate at the selection
Then
process.
where do we find staff pattern will not be applicable?
Now, staff pattern, I tell you also page 10 of the
Page
staff
10
pattern.
of list of dates.
No, page 10 of the compilation.
Yes.
You'll also
Why do
will
you
find-
say staff pattern is not
Now,
required?
why I am placing melody page 10,
Uh,
you'll also see two.
No, your
language group.
argument is there were two conditions.
Well, that
One
is why
staff
melody, that
pattern.
is why I am placing melody.
Hmm.
Page 10, 2 for high school, high madrasa, higher secondary school, language group, your lordship.
Hmm.
4 posts.
4 posts.
2 posts, pass degree. 2 honors / on a postgraduate degree. So, well, the 4 posts out of 2 pass category, out of 4, 2 pass category, 2 honors or postgraduate category.
We understand. So you are saying 2 posts, same qualification.
Recommendation comes from the School Service Commission. Either if the pass category, he will get pass scale, pass category scale. If the recommendations, my lord, the honors category, he will get, my lord, the honors scale of it. My lord, this 13 July 1999, this is amendment made, my lord, you will also kindly see page 7 of the compilation. This has been amendment of ROPA 98 that the justified as per the staff pattern. By this amendment, honors teacher also will not get postgraduate scale under postgraduate category.
No.
Because of the amendment, because his recommendation based on qualification honors degree, he will not get postgraduate. That is why this has been amended. Next page. This has been amended by 3rd June 2002 notification. Next page.
Read from the top.
With reference to his memo dated 22nd April 2002 on the above noted subject, the undersigned is directed to say that the question of granting higher scale of pay to honors graduate teachers having postgraduate degree in the subject relevant to their appointment working in non-government aided secondary schools and madrasa after being selected by the concerned School Service Commission has been under consideration of the state government for some time past. It is a fact that honors graduate candidates have to compete with postgraduate candidates on the same set of syllabus and same set of question papers in the test held by the West Bengal School Service Commission for selection of teachers. Moreover, the School Service Commission prepares a single panel in a subject from amongst the selected honors and master degree holders. Same set of selection, that is why, my lord, the 99 circular has been amended by this notification.
So, Mr. Jana, then what happens to the staff pattern? Staff pattern word has been included in the ROPA 12.3.
Yes.
Now you are telling us that staff pattern from these examples you will find that staff pattern is not required.
Staff pattern.
Physical education, you are saying there is no postgraduate qualification in physical, only there is no honors
or postgraduate in the physical education teachers. There is no, even
physical education, there is no honors, there is also no
postgraduate.
Then what is MPEd? Masters in Physical Education?
That is a postgraduate. No honors qualifications. B.Ed to post MPEd. B.Ed, there is no honors degree in the all over India. There is no honors.
You are saying that in respect of physical education, there is no honors course.
Yes. B.Ed means Bachelor of Physical Education or Master of Physical Education.
The entire
no, Mr. Jana, there is a circular which clarifies the circular of 4th September 1998, page 10.
4th September
1998 circular,
September 98, page 10 clear page 10.
page 10 of your list of documents.
Yes.
This staff pattern will not be necessary for physical education. There is a circular. So far as maybe I have forgotten, but so far as I remember, I am searching for that circular. So that Mr. Chattopadhyay will know it. One circular.
What circular is that?
Gaurav Das Vigri. He is keeping quiet. He's
Yeah,
keeping quiet. He knows.
আছে
ওই headmaster ma'am টা দাও।
My lord, prior to that, my lord, may I read it, the Boishali Banerjee, just exactly on the, my lord, questions involved in this case, my lord,
sure.
kindly.
No, I didn't understand the last argument of yours, that you are saying to make arrangement for honors graduate teachers to get the postgraduate scale of pay. Our government said that there is one examination for honors and PG, so you cannot discriminate. So those who have appeared in honors, they will be reflected in the commission recommendation as honors graduate. But he, after getting that postgraduate, he will get that.
That is why amendment is required. That is why 13 July 99 has been amended in 2002. My lord, that is the 2002. That is
13 July amendment is read over by the circular of 3rd
June 2000.
3rd June 2002 and not amended.
That has no amendment. My lord, page 8, last 2 lines.
Page 8, last
The last sentence of para 3, such and such,
Achha,
amending is
yes,
further
yes.
amended.
Yes.
That has been amended. That because this confusions, my lord, on the my lord, honors teachers join.
But the staff pattern has not been amended.
No.
Staff pattern has not been amended, not required.
Let us read together. Provided that such higher qualified teachers in the relevant subjects is justified as per approved staff pattern of the
Staff pattern. Because this staff pattern not required, amendment is not required. Because this staff pattern, my lord, the honors teachers, if the improved qualification postgraduate, my lord, after 2002, he will get.
No, that is your argument is it is a physical education.
Physical education staff pattern is not.
But I am asking you that what happens in respect of other stream teachers. That suppose in the school there are 3 science group 4 teachers, 2 postgraduates, 2 graduate. So in a school where is there 3 postgraduate and 1 honors, what happens on that? Then the another person applying
That can't be, because he will be appointed either in pass category or in postgraduate category.
Right.
In one category, there are 3 honors teacher or postgraduate teachers. That can't be. And your lordship, regarding physical education, after the 99 circular,
physical education, we accept this analogy. Yes. Because in physical education staff pattern also there is no segregation.
Yes.
As honors or graduate and postgraduate, because there is only one graduate. There are master degree candidate in physical education also, Mr. Jana.
Yes.
Then why they are saying work education, 2 posts?
2 posts, one work education, one physical education.
2 separate posts. One work education.
2 separate.
One for work education, one for physical education.
There is no mention about pass category or honors category. Your lordship will find, my lord, the page 10, the work education.
Then what happens in respect of this is in respect of high school. This is high school and higher school normal section. So how it has been explained in Boishali?
Yes. Your lordship kindly see. This issue has been, my lord, examined and discussed about. This exactly. This page number 3, my lord, start from. Your lordship, may I read it? The appellants was a postgraduate degree holder in physical education. Your lordship, after skipping over 2 pages.
Judgment starting.
Judgment starting. Page 474, my lord.
Yes.
Appellant was a postgraduate degree holder in physical education. She was selected for the post of physical education through the regular recruitment process conducted by the School Service Commission. At that stage, her graduate result was yet to be published. She was recommended to Siti Ramakrishna Singh Girls High School as a physical education teacher as past graduate, your lordship marked it. After declaration of her result, she applied for higher scale, which was denied by the state. She approached the learned single judge. Learned single judge, by the judgment and order dated, dismissed the writ petition after observing that, in view of the Control of Expenditure Act, they are not entitled. 2. Identical question was gone by Indira Banerjee in the case of Bhaskar Chakraborty. His lordship, by judgment and order dated September 22, 2004, allowed the writ petition and directed extension of postgraduate scale to the writ petitioner therein, who was identically circumstances with the present appellant. A belated appeal was filed along with an application for condonation of delay, which was dismissed by the division bench by judgment and order dated December 12, 2006 in matter number such and such. We are told state accepted the said order and extended the benefit to the writ petitioner therein. Learned counsel appearing for the appellant submits that, citing the said decision in the case of Bhaskar Chakraborty, several orders were passed where the state government extended the benefit. Mr. Soikat Banerjee, learned counsel appearing for the School Service Commission, contended that teachers appointed through School Service Commission are entitled to pay as per their qualification recorded by the School Service Commission and mentioned in the respective letters of recommendation. In the instant case, the appellant was a past graduate. Accordingly, she was recommended. Her subsequent acquisition of postgraduate degree is of no consequence, as her claim for higher scale is hit by section 14 of the Control of Expenditure. Mr. Bhudev Bhattacharya, learned counsel appearing for the state, while adopting the submission of Mr. Soikat Banerjee, contests that when the appellant was appointed in a past category, she was not entitled of to higher scale of pay for postgraduate qualification, as that of was not mentioned by the School Service Commission while making a recommendation of her appointment. We have carefully perused the pleading and judgment and order of the learned single judge.
Next paragraph. From
paragraph 7. The issue discussed.
Prior to 6, paragraph 6, please.
Paragraph 6. Prior to 96, the state from time to time extended the benefit of higher scale to the teachers who acquired postgraduate qualification in course of service. Initially, such extension was restricted to subject relevant to her teaching. The said rule was relaxed, and the postgraduate degree holders, being pre-96 appointee, were all extended postgraduate scale. Such benefit was given by the state probably to encourage the teaching staff to improve their qualification for the welfare of the student. Our attention has not been drawn to any other reason for extension of such benefit by the State Council. If that be the position, there could not be any distinction between pre-96 appointee and post-96 appointee. The issue was discussed by us in detail in the case of Samsundar Mohanto. There we held that a candidate, while applying before the School Service Commission, concealed his higher qualification and opted to be selected in past category, was not entitled to higher pay. However, in view of 2002 circular, that is the 3rd June 2002, 3rd June 2002, that I have compilation, I have just now. In view of 2002 circular, if someone of honors category and subsequent acquire postgraduate qualification, he would be entitled to the benefit of higher scale of pay. The case in hand is, however, having silent feature. The appellant is a physical education teacher. There is no honors course taught by any of the university in the state. Hence, there could be no such category in the School Service Commission in the concerned subject. We also do not find any such distinction being made in physical education by the School Service Commission. Hence, all candidates who are having appropriate qualification in physical education are considered in one category, that is pass category. If that be in position, their subsequent acquisition postgraduate qualification cannot be equated with any other subject. In the instant case, the applicant undertook the postgraduate study. She appeared in the postgraduate examination. Before the result could not be published, she was selected and appointed in the post. In the case of Bhaskar Chakraborty, the identical situation happened. Hence, in our view, the applicant was entitled to the benefit of higher scale of pay. This is the exactly the physical education teachers, only the school service commission.
But you also got the degree after joining service. And you are
after joining
post school service commission control
no,
of
I am the then managing committee. I list of date I have given.
Acha, finish this up and then come.
Let us now examine the said Act of 2005, that is the control of expenditure. That is not applicable to me, however.
Why? Retrospective effect.
That to that I have given, my lord.
So, Boishali Banerjee is not a case applicable to you?
Yes, is applicable. There are two grounds. One, my lord, I was appointed as a postgraduate teacher. Another, my lord, the control of expenditure.
No, you were appointed when? After the school service commission, through school service commission appointment?
Prior to that.
Prior to school service commission.
My lord, actually, I was appointed, my having qualifications, my lord, the B.Ed, I was appointed and placed, my lord, the science group. School made a proposal to the DI that he should be shifted to the physical education group. The DI has sanctioned and shifted to physical education group. That has been shifted. I have annexed also the sanction order. That has been shifted 96. Thereafter, I obtained enhanced my qualifications. That is my last date of examination in 2000. Though I am not appointed, I was not appointed through School Service Commission, but the after amendment of 13 July 99.
Appointed after amendment of 13 July?
July 99, my lord, the justify the staff pattern and qualification mentioned by the school. Though, my lord, that is why DI said this circular is not applicable to you. Impugn order, you logically DI specifically said.
So ultimately, Boishali what held?
Boishali was held. You logically see. Yes. Let us now examine the said Act of 2005 to find out whether there is any hindrance in any way in the way of extending higher scale of pay to the applicant. Applicant was appointed in 2001. She acquired postgraduate qualification in 2001. Hence, she was to be considered contemporarily. Her case was unnecessarily kept pending. Her prayer could not be considered to her disadvantage under the provisions of the said Act of 2005 in this regard. Learned counsel appearing for the appellant has successfully drawn our attention to section 16, wherein it is provided that the notwithstanding anything contained in the said Act, the terms and conditions of service of a teacher shall not be varied to his or her disadvantage in the view of the commencement of the said Act. In the circular of 3rd June 2002, the state considered the cases of the candidates who were undergoing postgraduate studies or had appeared at the postgraduate examination, but result was yet to be published. Those candidates, if selected in honors category, were extended postgraduate scale.
After June 2002.
That have annexed, my lord, in my
yes.
That is the, my lord, the amendment of 13 July.
Jana, you are not coming within this.
Yes, I am not coming. I have placing that the 13 July 99, that the justified staff pattern, that is also not applicable to me. DI has, my lord, the single bench considered, my lord, that again third time remanded to the.
Achha, you come to that fact. Now show.
অনেকগুলো থাকবে
Physical education.
ফিজিক্যাল
Did you get that?
My lord, 3 bits are
কালারফুল মার্ক ফ্ল্যাগ মার্কস
that are related to the physical
physical education. Granting of higher school.
আমি খুঁজে পাইনি
অনেকগুলো দিয়েছে which is
Blue.
হ্যাঁ
এই দেখো
June.
And then do clarification of
যাবো
এই বইটা নিয়ে আসো না একটু।
No, 0795,
এই তিনটা ডিফারেন্স
0407.
সেকেন্ডটা সেকেন্ড
ফার্স্ট জুনটা কোথায় ফার্স্ট জুন which year
759.
ট্রেন ফাইন হলো বাই নভেম্বর 898 আমার লেখা হয়নি
735 3rd June
That is staff pattern. So that is related to staff pattern and into that is related to qualification and physical education granting of higher qualification. Well, may I speak in a pencil?
একটুখানি দাও
চলছে এই তো আছে হেডমাস্টার ম্যানুয়াল তো আছে তো
ওই তো ওটাই তো
এই যে আরেকটা আছে তো
898
that circular Mr. Das where says that staff pattern is not required in physical education
কত জিও বার ডেটটা বল
please read it
91
1993 759
sir what is the date
22nd November 22nd November 1993
27th
November 22nd 22
22nd November 1993 yes
that is the irrespective of staff pattern after ROPA 90 that is not applicable after ROPA 98 that is the problem whole problem 93 circular after ROPA 90 irrespective of staff pattern because ROPA 90 also my lord the benefit was given to all and kindly see the 93 circular that I know 22nd November 1990
you are saying about the ROPA 1990 first 12/3 of 1999 ROPA this is 98 ROPA
কিছু করতে হবে না তো ঘর যদি 3% ইনক্রিমেন্ট
nine 98 ROPA you showed us clause 12/3 98 98 ROPA clause amended on 3rd June 2002
first 13 July 99 then 3rd June 2000
amendment of that
amendment
now this amendment of
93
just a moment
92
there was no mention of staff pattern in the 98 ROPA
99 yes
98 ROPA
there
was no mention of staff pattern.
Required qualification mentioned those teachers
Then when it was 12/3 when it was amended on 13 July 99
there is
they added
staff pattern
this was in 99 but this amendment was made without taking into consideration the 93 circular operating that in physical education no staff pattern required.
staff pattern 93 circular 22nd November 93 circular your lordship will find 372 31st July 1981 that is ROPA 81
ROPA 80 এর সময় before 98
that has not
there was no as government before 98 93 circular is this one said that no staff pattern required for physical education that is why when 98 ROPA was brought in there was no condition of staff pattern in the ROPA 12/3 original
12/3 no there is no condition
now amended in 1999
13 July
School Service Commission came in the meantime
but this staff pattern again was brought it
but the that staff pattern is not applicable in this case of physical education.
That is a separate argument. But this incorporation of the staff pattern was abolished by the state. So the amendment ought to have been that you give qualification on the basis of the qualification mentioned in the recommendation of the commission. Commission Act came in 97, 93 circular, control of expenditure 2005. Control of expenditure section 14 that don't disturb whatever has been done to the teachers. So this argument of 93 non-requirement, this was not there in Utpal Khan. You check it up. I may be wrong. I may be wrong. Acha, now come to your
That was my lord the submissions by the learned advocate general. Page 30, paragraph 36. Mr. Advocate General submits that the aforesaid rule contemplates teachers who have already improved their qualification or would improve their qualification or who were appointed with higher qualification in the subject or group relevant to their teaching appointment to get higher scale of pay with effect from 1st January 1986 or the date of improving qualification, whichever is later. It would thus benefit.
Education graduate হয় আর পোস্ট গ্রাজুয়েট হয়, কিন্তু অনার্স গ্রাজুয়েট হয়। আর স্কুল সার্ভিস কমিশন যখন ফিজিক্যাল এডুকেশন অ্যাডভার্টাইজ করতে রিকোয়ারমেন্ট there is no honors. There is no honors all over. Hence their enhancement is not enhancement to যারা পোস্ট গ্রাজুয়েট যারা
Various types having master degree in physical education from recognized university will be entitled to get higher scale of pay in relaxation of the above noted stuff.
So read from the top. Undersigned is here to say that it has come to the notice of that a higher scale of pay is not being granted to physical education teachers having higher qualification of master degree. This is presumably due to non-existence of any provision for postgraduate teacher in physical education in terms of the staff pattern of 1974. In department memo of 31st July 81,
That is ROPA 81.
33 EDN,
And
the
this is
higher
ROPA 9.
scale of pay of teachers of say having higher qualification has already been granted. It is now clarified physical education including those madrasas, various types having master degree in from recognized universities will be entitled to higher scale in relaxation of the above noted stuff. Confusing. Now, what is your case?
My case, my lord,
Utpal Kanti Karan, you give us those paragraphs. Go through it. Please go through it today and give the paragraphs to us. Hand over one paragraph number note to our court officer tomorrow. And now let us understand what are the facts of this. Come to the order under appeal. Page 145.
my lord, the I prepared a list of dates.
Yeah.
The short list of dates, your lordship, once kindly consider.
Yes, list of dates. Yes, list of dates.
The 91, the petitioner joined as assistant teacher, 91. My lord, he was placed, his appointment was approved in the science and mathematics groups. Though he had qualification, my lord, the diploma in physical education. My lord, in 1996, my lord, the proposal of the school, my lord, to change the group from science group to physical education group, work education and physical education group, that has been sanctioned by the DI.
When?
That is the, my lord, the 26 June 1996. That I have also enclosed, my lord, in my list of dates.
26
June 1996. Now I have been shifted, my lord, the
26 September 96.
26 September 1996, sorry.
To inform the proposal for change of group as BSc PPA. So then in work education, what is 10th of August 1996? In this we find that there were 3 teachers.
10th of August, my lord, that is I have annexed in the list of date, your lordship will find list of date.
There are 3 teachers.
Just my lord, after the sanction order, next page, there are 3 teachers. Your lordship will find 3 Pradeep. Your lordship at the bottom, page, list of date explanation. My lord, lordship will find
Pradeep Biswas.
Pradeep Biswas, that is another
There are
person.
2 Pradeep Biswas.
Pradeep Kumar Biswas, second one, my lord, the petition appellant.
Achha.
Third, my lord, the Pradeep Mitra Mojumdar. All of them right hand side qualification, BA, BPA, BSc, BPA, BCom, BPA. All are, my lord, the enjoying pass category scale. After the 1996, I enhanced my qualification. Last date of examination in 2000. 17 June
for higher scale of pay.
17 June, my lord, I acquired MPA and my lord paid for higher scale of pay.
Now rejected as per 2008.
Yes.
Division bench.
Dismiss the writ petition, my lord, on relying, my lord,
So division bench said that set aside the order of the CM with a direction to sanction
mandatory order to grant postgraduate scale of pay.
Still they did not give.
That is, my lord, the page 67.
The sanction করলো তো 16 June 20.
Yeah, has sanctioned. 16 June 2017.
Then
subject to outcome of the application for recalling.
Oh, in that appeal. That was state appeal.
State appeal. No, outcome of the recalling application.
Oh, acha. They preferred a recalling application.
Recalling application. Recalling of the order of the division.
So you were not given the scale. Then what happened?
Recalling applications, my lord, was pending. What I'll do, I moved the writ petition. 6 July 2018, the Honorable Single Judge directed to give the benefit in terms of the sanction order.
At that time, you did not say that it has already been sanctioned due to
sanction. That is, but benefit was not given.
What was the order direct? 77.
77. You'll also kindly see.
কি বললো?
77. List of
so your sanction has not been recalled as yet?
Sanction has been recalled because the subsequent against this order, state has preferred an appeal.
Page 77.
77. 79, my lord, the operative part. Accordingly, the District School Kolkata is directed to immediately grant the benefit not grant the higher scale of pay, grant the benefit. And that has been quoted, sanction order has been quoted, my lord, in the order itself. First page 77.
Now then what?
Now state has preferred an appeal. Page 80.
This is the appeal.
No. Another appeal. State preferred an appeal.
Yes. Then heard the appeal along with
appeal can has been dismissed because the recalling application has been dismissed and posted the appeal to be heard.
No, this is MAT. Earlier appeal was 174, FMA 174.
That is disposed of and directed to grant postgraduate scale of pay.
Thereafter, the recalling application was pending. Then what happened? Now,
I moved a writ petition because
we understand. Now
the
next new appeal is MAT 1455.
Challenging the order of the single
Justice Shekhar.
And also recalling application was taken up together, both.
Oh, which was surviving? How that survived? The appeal to chole geche. So how the recalling application can 5603 was taken up?
That is why can has been dismissed.
No. This is must be a separate can taken up.
No. Can number you will also kindly
5603.
5603 can, my lord, recalling of the order of Justice Pranab Chattopadhyay.
FMA 174.
That is 174. That has been dismissed. Now the honorable division bench considered the present appeal. Not present appeal, my lord, the appeal.
Appeal against the order of Justice Shekhar Saraf.
That order I have annexed page 82.
Now what did the appeal court say?
Appeal, my lord, that is, my lord,
both the recalling and this was heard.
Recalling on hand, recalling has been dismissed and, my lord, the appeal.
So again directed to consider.
Considering the staff pattern, my lord, that was. Now the DI has passed this order. That is understood. That has been said.
No. এখানে সৌভিক ঘোষ দেখিয়েছে.
So that is why, my lord, the state has filed a recalling application that Shovik Ghosh is not applicable. Relying Shovik Ghosh, my lord,
Tarok Rai was Tarok Chandra Naina.
That is regarding different subject, not physical education.
No. Recalling basis of the application that a coordinate bench relying upon Shovik Ghosh. Report in allowed the revision which has been stayed by the Supreme Court. Then what happened? Supreme Court, it is still pending?
No, that is, my lord, directed the bench to be constituted, and that is why, my lord, the Utpal Kanti Court.
Oh, acha.
As per order of the Honorable Supreme Court, Utpal bench has been framed and the judgment has been. That is the regarding
the present issues whether provisions would be applicable in view of the improvement of qualification before the act came in.
No, that is the honorable division bench has clarified that Shovik Ghosh is not applicable to my case.
What was Shovik Ghosh?
Shovik Ghosh, my lord, the past graduate teachers can be entitled as per the Control of Expenditure Act. But the Shovik Ghosh is not applicable. Also, page 88, third paragraph, that has been, we make it clear.
The qualification on master degree, but he entered into as a postgraduate category. After entering into service, he claimed that I have the postgraduate degree. That could refused.
Suppression of qualification.
Suppression of.
That is
suppression.
That was Tarok.
Yes, Tarok Chandra Rai. And that is upheld by the Supreme Court.
But Tarok was delivered by Jayanto Biswas.
No, Justice Ashim Banerjee. Presided by Justice Ashim Banerjee.
No.
Tarok Chandra Rai, my lord.
Tarok Chandra Ashim Banerjee.
No.
Tarok was by Jayanto Biswas.
No, the Honorable Justice Nijjhar.
Your Lordship appeared on behalf of the
Jayanto Biswas. Justice Nijjhar. No. Justice Nijjhar and Tarok must be Justice Nijjhar and Jayanto Biswas dismissed it. Now Tarok, I think, is of Indira Banerjee. Honorable Justice Indira Banerjee.
Yes. Tarok Chandra Rai, the Honorable Justice Nijjhar.
Now this order was upheld by the Supreme Court. So Nijjhar Sahib's judgment to chole.
Yes. With Mr.
Sitting with
the Jayanto Biswas.
Oh, Jayanto Biswas.
Your Lordship appeared on behalf of the SSC.
সে ছিল নাকি?
Now what happened?
Now the
Shobik was not relating to physical education.
that has been discussed. Division page 88, third paragraph.
88. Now that
We make
MAT.
We make it clear that in view of our earlier order,
Page
88, 86.
In view of our earlier order 20 disposing, it would not be open for the DI to deny the claim on the basis of Shobik Ghosh. Our order dated Ato has been accepted. Where we have specified that a decision is not applicable to the present case.
So relying Shobik Ghosh, my lord,
So Can was dismissed, but the appeal was kept alive.
Another appeal against the Justice Saraf, order of Justice Saraf.
This page, so this
Can, my lord, the recalling of the order of Justice Pranab Chattopadhyay, first appeal, where the mandatory order was passed.
This was passed on 20th December 2019.
2019, that is the Can application.
Can application. When was Justice Shekhar Saraf's order?
Shekhar Saraf, my lord, the second writ petition
is of 2018.
18, but after this order, state has preferred an appeal against this Justice Saraf's order, and application was filed recalling the order of Justice Pranab Chattopadhyay.
So both were taken up. But
both are taken up. And the Can has been
now. Then why didn't you say that the DI has already sanctioned?
It is the state's contention that according to the staff pattern, I was not entitled. I am not entitled. That is why.
Where is that? Where is that?
You will also kindly see.
Page 80.
Ultimately, this honorable court, page 85. Page 85. Yes.
Page 85.
85. On mere reading this amendment of paragraph 12, subparagraph 3, that is 13 July 1990 amendment, it appears to us for extending the benefit of higher scale of pay, staff pattern of the school is relevant consideration. Which
is a relevant consideration.
That is the melody, not.
So how can we disobey this?
No, I tell you, so ultimately, since the district instructor school is the appropriate authority to consider the claim of the writ petitioner relating to postgraduate scale of pay, upon considering the position of the staff pattern, which was subsisting at the material point of time in the said school.
Tahole the staff pattern, you have to show that the staff pattern requirement is not operative at all, and from that utpal karon. Otherwise, we are bound by this judgment.
You'll also kindly see. What was the ultimately last paragraph? We find it apposite that remand the issue back to the concerned district inspector of schools, AC Kolkata, for reconsideration upon taking note of the relevant provisions as contemplated under paragraph 12, subparagraph 3, read with the amendment provisions which was introduced by notification dated 13 July 1999.
Maybe.
And your lordship's melody, accordingly, we direct the district inspector. Your lordship said the impugned order. What are the DI's melody views?
Whatever may be the view, Mr. Jana, this observation, page 85 beginning, on mere reading of the amended to paragraph 12, it appears to us that for extending the benefit of scale of pay, staff pattern of the school is a relevant consideration.
DI said this amendment has not applicable to him.
Where?
DI said impugned order.
DI say?
Page 92.
Page
92 in impugned order start. Impugned order means melody passed by the DI. That is melody, your lordship will see 93 at the bottom. As per GO number 670 dated 4th September 1998, that is the staff pattern. And GO number 14 dated 8 January 1998, that is the recruitment rules. Page 93.
Yes, where you are reading?
From the bottom, third paragraph. As per GO.
Don't come to the third, come to paragraph 2.
Paragraph
92. It has been found in the staff pattern of that period that 3 assistant teachers were working in work education.
Yes, that is also in my favor.
Pradeep Kumar was the second person. First
Second
one was Pradeep Bishas.
Yes.
Now Pradeep Bishas expired.
Expired.
Now Pradeep Mitra Majumdar was the third approved teacher working with effect from 90 and he was shifted to social science group. Pradeep
Yes.
Kumar Bishas enhanced in the year 2000. Teacher submitted. So you remain to be the only person in
Only
the,
person. Even in terms of the observation, I am entered.
now what you are reading geo as per high scale, which portion? As per geo
As per geo number 670 dated 4th September 98, that is staff pattern. And geo number 14 dated 8 January 98, that is the recruitment rules of School Service Commission that are enclosed.
Acha.
And qualification of 2 assistant teachers
ছেড়ে চলে যাচ্ছে and approved staff pattern of the school. As per geo 4th September 8th January 98 and approved staff pattern of the school.
You'll also smell the page
93 penultimate paragraph. As per geo 670.
Yes.
After Roman 1, 2, 3
and geo number 14 geo number 14 dated 8 January 98, the qualification of 2 assistant teachers in work education and physical education group must be bachelor degree with degree diploma in work education or physical education. You'll also next. In the present case, at the material point of time, the petitioner was the second teacher of the aforesaid group as per staff pattern, and graduate scale of pay is admissible in favor of the petitioner. As per geo number 670 dated 4th September 98 and geo number 14 dated 8 January 98 and approved staff pattern of the school, the higher qualification MPA of the petitioner for work education and physical education is not justified. This they said, my lord, as per 1498, my lord, recruitment. Last line. Next. So 155 dated 13 July 99 is not applicable in favor of the.
Where you are reading? So 150 13 July is not applicable in favor of the petitioner. Why?
They said, my lord, the 155 as per the
staff pattern.
Staff pattern, I am also entitled. Even my lord,
why he is saying?
They said, my lord, the 155 only those persons who are recommended by the School Service Commission. If it is not applicable, unamended ROPA amended. Even then, my lord, there are 3 teachers, one died, one shifted, alone, my lord, I am entitled. So there is no, my lord, the single judge again.
Where do I find, try to understand, Mr. Jana. Shobhik Ghosh passed an order, division bench judgment, which went up to Supreme Court. Ultimately, bench was constituted. So this issue of staff pattern must have merged into the judgment of Utpal Kanti Karan. So because without Utpal, we cannot touch. Because this finding is binding upon us. Coordinate bench says that staff pattern has to be considered. Shobhik Ghosh said staff pattern has to be considered. There was difference in opinion. New bench was constituted. Show us where Utpal decided the issue of staff pattern.
I will show the issue of the staff pattern that has
apart from your contention, we understand that if you treat me as a pre-School Service Commission appointee, I was appointed prior to School Service Commission Act. At that time, 1993 circular did away with the staff pattern of the school, not required. So, on the basis, that was never argued. It was not argued. Now you are arguing that today, that even if this observation is here, you cannot deny my entitlement since I was an appointee prior to the Commission Act. এখানে ultimately কি বললো দেখি? As per geo of next page, 21st December 2000, no vacational MPEd has been allowed higher scale since it is not a single course.
That has been
set aside by the single judge.
That has been set aside by the learned single judge. I have not come with the appeal, my lord, against. Only that portions, my lord, again directed, DI was directed.
Set aside by single judge earlier.
This
matter.
This order.
Because my lord,
This
that
order,
circular was issued, my lord, the regular code, there should be a regular code. So for this reason, that circular come into effect after this.
After 2000,
Yes.
prospective effect.
Yes.
I obtained my lord degree.
93 ডিএটাতে কিন্তু ও এই কথাটাও আগের অ্যাপিল কোর্টে এন্টার হয়নি বলে ওকে in view of the observation, DI is not in a position. So on two grounds rejected.
Two grounds.
One's 2000 circular and the other is
Staff pattern.
staff pattern. But I don't understand staff pattern also you fulfill because you were the sole person there.
Sole person. That is on that score, my lord, I am entitled. Even then, my lord, the staff pattern applicable or not
In
applicable.
Shovik Ghosh, Mr. Chattopadhyay, what was said?
Okay, cool subject. Cool subject.
Hey, Mr. Das, Shovik Ghosh, what did Shovik Ghosh said? You appeared along with Mr. Chattopadhyay. Mr. Chattopadhyay will not do such homework. You have to do the homework.
Yes, ma'am. Tarak Chandra Rai, my lord, has been discussed in.
Shovik Ghosh, my lord,
Qualification Code.
Chief Justice Nijjar and my lord,
Discussed.
Yes,
the
Tarak Chandra Rai.
Honorable
And upheld Tarak Chandra Rai.
my lord,
But that judgment is not
Relevant in this case.
no, that judgment is not relevant for him, na.
Yes. But Tarak Chandra Rai, my lord, that has been upheld by the.
Now, Tarak Chandra Rai said that whatever qualification is mentioned,
He has, at the time of entry, he was master degree. But he was choose to appear as a pass category. Now entering into service, he claims that I have a master degree.
so in Tarok, that relief was denied.
Denied
Tarok
by the division bench,
Shovik
and that
Ghosh-
was upheld by the Supreme Court also.
Shovik Ghosh, my lord, the
Shovik Ghosh, whatever.
Shovik Ghosh, my lord, the Justice, Chief Justice Nijjar and the Honorable Justice Indira Banerjee, my lord, the allowed the Shovik Ghosh to
Now,
grant postgraduate
Utpal Kanti
physical
Koro.
education.
Whether
But
Utpal,
this my lord,
Shovik Ghosh also went up in appeal.
went up in the appeal. But the Shovik Ghosh problem is he enhanced his qualification after the control of expenditure.
No, no. Then ultimately, what happened? Why? Who framed the issue before Utpal Kanti special bench?
Both,
Court
my lord,
Framed the issue on the point of the
Supreme Court framed the issue in which case? Shovik Ghosh case or Tarok Rai?
Tarok Rai.
both,
sending the matter to the larger bench only on the restricted on the point of section 14 and 20 of
Xerox করা ছিল গো।
expenditure and extent of that sections to be.
Then these points how can be covered under?
My lord, all these points, even my lord, the 99 memo, my lord, that was 1993 memo has also considered as important.
Then ultimately, what did the court say? This is a big judgment.
Yes, my lord, I have a Xerox.
Almost 100 pages judgment.
ultimately, my lord, that was
I
my.
carried it home twice, but I couldn't.
Well, so far I mean, knowledge goes, my lord, ultimately it has been observed that those teachers who have before entering into service, they are enrolled as in master degree, they are entitled for higher pay scale. Because after Control of Expenditure Act,
No,
they
ultimately,
enroll them.
Past graduate will not get any.
Past graduate will not get any benefit.
That is the
But
main-
those teachers who has already enrolled in master degree,
Enrolled in the sense, Mr.
master degree course,
Oh, acha, acha. They will be given.
they will be given benefit through postgraduate scale.
I will give
And
my
past graduate,
photocopy of the
past
entire
graduate
judgment.
not entered. জজ সাহেবরা আছে বলছে দুবার নিয়ে গেছে। আচ্ছা, আমাদের
It's a very big judgment. And it started with discussing career advancement scheme and grant of postgraduate scheme. There is a big discussion on that. Please help us, Amar. Also, we have extensively heard Mr. Jana, learned advocate, appearing for the appellant.
হতে পারে ঠিক না 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 ঠিক নেই হতে পারে মাইলর দি মাইলর কাইন্ডলি আদারওয়াইজ মাইলর দি স্টার্ট দিনে হবে না
রিপোর্ট ভ্যাকেশন হয় না
বলা যায় না
Yes, which is yours. Oh, that higher, that additional benefit. Oh, you got that affidavit, gave it to him. You said, "No, I will bring the papers."
Yes,
Brought-
that my learned friend, last occasion, my lord, he
Gave the
submitted
papers, gave the papers to you.
papers, yes, my lord, orders.
You
My lord,
said na that I.
My lord have asked for the resolution copy.
No,
That resolution copy is with me, my lord.
no, not yet submitted before the single judge.
Doesn't matter.
That is the matter,
That,
the order.
You
I have
give
collected
that
the order.
resolution copy to him na.
My lord, I will. And my lord,
Give
when,
that tomorrow.
my lord, when it will be taken?
This,
So that I cannot.
No, my lord, cannot, if it is any date in next week, my lord, tomorrow it's,
কি হয়েছে কালকে?
my lord, there is matter fixed in the
আচ্ছা Monday.
Monday, my lord, deeply.
developed.
আমি তোমায় কালকে তাহলে দিয়ে দিচ্ছি এই সব কিছু আমার কাছে নিয়ে নিচ্ছি।
এই সব তো শিখে দিলে হবে।